Good morning. Welcome to the Appellate Division First Department for oral arguments today. Thank you all for getting up early and joining us at our early 10 a.m. calendar call. We have approximately 7.5 hours of requested argument time. So I just want to say that because we're here early does not mean that we have to stay the entire day, okay? Please keep that in mind. Also, please keep in mind that we have read your briefs. We are fully familiar with your arguments, and so please only request the time that you actually need, okay? And if we need more time, we'll certainly give it to you, okay? First case on the calendar, I'm calling the calendar People v. Jose Pagan Montalvo. Submitted. Plaku versus 1622 Van Buren, LLC. Submitted. Matter of X versus Cho. Thought we had a pro se. Did you see? Did you see the pro? Yes. How much time are you requesting? It's Chen. I'm sorry. How much time are you requesting? 15 minutes. Okay. And how much time? 5 and 5. Thank you. Wilson versus Christ Alive. Submitted. People versus Michael Williams. Submitted. Flores versus New York City Transit. 5+2. Want to change that? Not exactly what I was going for. Why don't we just give you 3? Okay. 3 and submitted. Buffington versus Catholic School Region. Submitted. 830 8th Avenue versus Global at 8th.
Request 7 and 3, Your Honor.
Yes? Okay. So 5 and 2 and 5. People versus Gilbert Welsh. Submitted. Dolores C. versus Alberto C. Submitted. Ayala versus City of New York.
For the call, City of New York, 6 and 2, please, Your Honor.
Yes, counsel? 6 and 2 and 5. Silver Point versus Riviera Resources.
Good morning, Your Honor. For Appellate, we request 96.
And counsel?
Request 15.
Fine. 7 and 2, 10. People versus Hickcliffe Rosario.
Respondent requests 8 minutes,
7 and 2 and 7. People versus Cesar Cruz. Submitted. People versus Michael Rosario.
Yes, Your Honor. Request 4 and 1, Your Honor.
Yes, counsel? 4, 1, and 4. Banks versus Chan. Yes. 7 and 3 and 4. Taglioni versus Garcia.
Good morning, Your Honor. Appellate 7 and 2.
Yes, counsel? 7, 2, and 5. Glencore Limited versus Freeport Commodities.
Good morning, Your Honor. Appellate request 8 and 5. Good morning, Your Honor. Respondent request
7, 2, and 7. People versus Edward Roman. Submitted. People versus Marlon Carrion. Submitted. Mortimer Offshore versus Manufacturers Orga, submitted. Clinton versus Board of Elections.
Good morning, Your Honor. Can we felon 7 and 3, please?
Good morning, Your Honor. Respondent Castorina from say requesting 7 minutes.
Good morning, Your Honor. Other respondents requesting 1 minute.
7-3, 7 and 1. That matter, Justice Rodriguez is recused. Justice Kern will be sitting in that case, and that case will be called first. So Clinton versus Board of Elections. Okay. Okay. I call it. Very question. I'm getting fired. Okay, I'm just gonna fire. Thank you. I'm sorry, counsel, whenever you're ready.
Thank you, Your Honor. Thank you.
You want to get to the mic over there so we can actually hear you?
Appreciate that. Sorry.
That's okay.
Thank you, Your Honor, and thank you for the bench for listening to this appeal. This is an election law appeal. The ballots must be printed by September 24th, and that's why this is on an accelerated calendar. The sole issue we believe that should be addressed by this court is whether or not these so-called individuals claiming to be judicial delegates were necessary parties pursuant to Article 100 or Section 1001 of the CPLR. We claim they were not.
Can you tell me or explain to me what the distinction is between Action 1 and Action 2?
I'm sorry, Your Honor?
Can you explain the distinction between Action 1 and Action 2?
Certainly, Your Honor. Thank you.
It seems,
Action
Wait,
1.
counsel, 1 second. He
it
wasn't
seems to
finished.
me that Action 1 and Action 2, is essentially it's the flip side of the coin, isn't it?
No, Your Honor. Action 1 was commenced at a time when solely a certificate to fill vacancies was filed. That was the commencement of that action. When the Board of Elections took a position that, in fact, these were not delegates because they were not compiled pursuant to Article 9 of the election law, effectively Action 1 was deemed moot. The challenge, in essence, was the certificate of nomination that was comprised in Action number 2. We claim there were no delegates because they were neither elected nor compiled as is required by the election law. So to claim...
But to have a convention, you need delegates, right? To have a convention, you need delegates?
You need delegates. It's required by Article 6-124 of the election law.
So what does it matter? Because aren't you, in effect, attempting to strike the certificates of vacancy?
I'm apologizing because it's hard to hear.
Aren't you, I apologize about that, aren't you, in effect, attempting to strike the certificates of vacancy maybe implicitly and not explicitly?
No, Your Honor, because the Board of Elections, in fact, took that position when it didn't compile those individuals as delegates, which is required by Article 9 of the election law. Once that action or inaction of the board occurred, there were no delegates to be challenged. The bottom line is the certificate of nomination, which named 2 individuals as candidates for Supreme Court, and the people who proffered that certificate were the necessary parties, not these other people. If I had rounded up 20 people on the street, put them on a piece of paper and say they're delegates when they have never, ever complied with the requirements of election law, I would suggest to this court they were not delegates, they were not necessary parties, and they don't need to be named in the proceeding. And at worst case scenario, Your Honors, if in fact these individuals had some sort of participation in the proceeding, their position was adequately represented by the people who proffered their names on the certificate, meaning the chair and secretary who signed the certificate and the 2 candidates who were named who were the beneficiaries of the so-called nomination. That is what's being challenged here, Your Honor. We would not have even had standing to pursue an appeal of action number 1 because of the actions taken by the Board of Elections. The relief was effectively granted when they did not compile their names as delegates.
But if we do agree with your position and invalidate the nominating documents, doesn't that necessarily affect the determinations or decisions made by the judicial delegates in electing those candidates?
In the totality of cases that deal with judicial conventions throughout the legions of dating back to Wager and going straight forward, no instance can be found where the delegates themselves were necessary parties to any of these proceedings. The people who proffered their certificates were, the candidates were, and even parallel cases when parties have taken positions on nominations of candidates for other public office or other party positions. The delegates themselves to the convention are never necessary parties. The people who are proffering their nominations were even...
What's the test to determine who is a necessary party?
Whether they have under Section 1001 of the CPLR, whether their interests would be adversely impacted by the determination of the litigation. And here, that they are not adversely impacted, the delegates themselves.
So, counsel, you're saying that I run as a delegate. I think I want to pick a particular candidate. That's why I run. I go to my club events. I do everything I need to do to let people in my party know who I am. I buy tickets to things. And then I don't get to vote on who my candidate is. And you're saying I'm not affected?
I'm saying to you, they never reached the level of being delegates, Your Honor, because of the actions.
Not disagreeing with that with respect to the first. I'm saying they are affected by the decision. There's no doubt about it. They don't get to vote. And they've spent time and energy campaigning for themselves for this position. It's not something that you pick out of a hat. It's something that where people go to political events, they introduce themselves to the candidates, to the leadership, so that they can get this position, right?
Your Honor, in this instance, neither of those circumstances or any of those circumstances occurred.
So how were they selected as delegates?
They were rounded up by the party and placed on what's called this certificate of substitution, to fill vacancies, the certificate to fill vacancies without ever running for office, without ever campaigning for that office, without ever taking any actions otherwise required.
You're saying they just pick people from the street? They picked them out of a
No,
hat?
they took them out of their own party,
Exactly. So that was going to be my question. There was some process that was that took place. Whether you disagree with the process, but this was the process that took place by the party in order to select those delegates.
If this court were to find that they are necessary parties, Your Honor, I would strongly suggest that their interests in that process were adequately represented by the people who were named in this proceeding, meaning the people who proffered that certificate, who in fact signed that certificate on behalf of the nomination.
Thank you, counsel. You have time on rebuttal.
Thank you, Your Honor.
Good morning, Your Honors. May it please the court. My name is Ron Castorina. I'm a respondent pro se. And at the outset, I just want to disclose to the court, and not in any way to seek favor, that I am an elected civil court judge, and I am here pro se because we received late notice on Friday that a brief would be due on Monday, and it was logistically impossible to retain the counsel that I had sought to.
Counsel, can you respond to your adversary's last point that you and the other respondents adequately represent the judicial delegates?
The judicial delegates are not adequately represented by the leadership because what's being challenged here by appellants is not the acts of the delegates, but it's an existential attack on whether or not the delegates are delegates. And that's a very fine and important distinction, because if the appellants received the relief requested, then the judicial delegates would be stripped of that title, of that party office, and the court would have then violated their First Amendment rights under the New York Constitution and the U.S. Constitution for freedom of association. And they would have taken something of value away from these parties, from these delegates.
But that still doesn't answer the question why you folks can't adequately represent the delegates.
We cannot adequately represent them because they deserve an opportunity to be heard as to whether or not they themselves individually are valid delegates. It would be a taking by the court without giving them the opportunity to be heard. It would be violative of due process. These individuals have spent their adult lives as members of a party. They've participated in events, they've worked on campaigns, and they've been held in esteem amongst the party, and they've become delegates. And this is an important party position. And to just take that away from them without individually giving them a right to be heard would inequitably affect their interests. Thus, joinder is absolutely necessary, and the failure of the appellants to join these necessary parties is absolutely fatal to their petition, which is why it was dismissed. And action number 1 is res judicata on the certificate to fill vacancies. They then attack the certificate of nomination, and they try to backdoor this court by saying, well, we're just attacking the certificate of nomination. But the argument below distinctly and specifically attacks the actual genesis, the a priori originating document, the certificate to fill vacancies, which created the position of judicial delegates. So they're putting the cart before the horse, and they want this court to focus on the merits of the case. The court goes through great pains below and uses terms like, unfortunately, we couldn't get to the merits. The court wanted to get to the merits. The court wanted probably very badly to get to the merits, but the court recognized that the nuts and bolts issue here is jurisdiction. And if you don't have jurisdiction over the parties, well, then guess what? You cannot get to the merits because those parties who are inequitably impacted by the failure to join will not have an opportunity to be heard. And now counsel uses the wager case, but in wager, and this is a very important distinction, in wager, the court states precisely that all necessary parties were joined. And because the leadership of the Conservative Party was in fact joined, the delegates' interests were then represented. However, the claim in wager is very distinct and specific because it doesn't attack the very existence of the delegates. It doesn't attack whether or not they are valid delegates. It merely attacks the acts, the official acts as delegates. And so that is a very valid and important distinction. Only because appellants attack the existence, the fundamental basis as to whether or not the delegate is in fact valid or not, that is the reason why they must necessarily be joined to this action, because they are inequitably affected by the lack of joinder, and that is a fatal error. And it cannot be surmounted, and it cannot be countenanced because of the 10-day limitation, statute of limitations
Counsel,
under the election.
Put your mask up, please.
I'm sorry.
We're all
I know, it's just-
suffering. We're
I
all in the
apologize.
same boat.
Thank you.
Thank you. Counsel, let me ask you, if the delegates are struck, how are those assembly districts just not represented in the convention?
Well, appellants have two problems. First is the joinder issue, and then the second is the standing issue. They only were able to acquire one objector from one assembly district of the 4 assembly districts that comprise the 13th Judicial District. So out of the 28 delegates, they were only able to object to the existence of approximately 6 to 8 delegates of the 28. So they have a standing issue fundamentally on the certificate to fill vacancies on action number 1, which is also why Judge Edmeade rightly dismissed their petition.
But counsel, in action two, you're not pressing standing here, are you?
No, I'm not. But I am indicating, and I think it's a very important fine point, that you must talk about joinder and standing in action number 2, because the arguments made below by appellant as to their challenge to the certificate of nomination go back to action number 1. They don't say that the certificate of nomination was improperly filed or was late, or that there were any issues with the actual four corners of the documents that were filed with the court. What they say is that the delegates are not valid because of the certificate to fill vacancies is not valid in their opinion. And what they did here, Your Honors, is they prejudged the case. They made a predetermination that the judicial delegates were not valid, and that actually was the job of either the Board of Elections or the court. There needed to be a judicial determination, and unfortunately for appellants, they made that determination afterthought, and then they failed to join the delegates.
Thank you, counsel.
Thank you, Your Honors.
Your Honors, on behalf of the five, good morning. On behalf of the 5 respondents, I'm going to rest on the arguments of my colleague, and thank you very much.
Thank you. So, counsel, you have 3 minutes in rebuttal.
Thank you, Your Honor. Again, the question that seems to come to the fore at this point is whether or not these individual so-called judicial delegates were adequately represented by the other parties named in the proceeding in action number 2. We assert that they were. They were, in fact, not campaigned, not spent time, effort, and energy.
You know, I understand that the process was different than the process normally is.
Right.
But ultimately, didn't the delegates exercise some judgment in making a determination with respect to who to support? And so under those circumstances, if we were to strike the nominating documents, aren't they affected by that determination?
No, Your Honor, and I think Wager is instructive in that regard. Wager had a similar process. Delegates weren't elected in conformity with the law. The case was brought. They were not named as necessary parties. The leadership of the parties who tried to proffer their names were named and found to be adequate parties to fulfill the obligations under the CPLR. It is no different here, Your Honor. Again, they did not have any independent standing on their own to be served and named in these proceedings. Thank you.
Thank you, counsel. We'll wait for Justice Rodriguez to return. Next matter is Ex Hoxham. Excuse me. Matter of Chen X.
Good morning, Your Honor. So, good morning, Your Honor.
One second, counsel. We're waiting for the Justice Rodriguez to return.
Sorry about that.
That's okay. Just let him get situated, and then you begin your argument.
So the case number is 2020-03583 regarding my 8-year-old Haoxuan Xia. And respondent, Honorable Justice, respondent appellant commenced this proceeding seeking the dismiss of ACS New York's petition against Chen Xu regarding my 8-year-old Haoxuan and release Haoxuan back to family members and also from foster care. Then the key issue of the case is whether Haoxuan is a neglected child as Family Court Act 2012 and the Social Service Law 412 defined, whether Haoxuan should be kept in foster care as ACS also confirmed Haoxuan's diagnosis. Haoxuan was diagnosed as UTI on February 5th, 2019, while the white cell is 500 and the normal test result should be 0. The doctor made the referral to the cardiologist, urologist as soon as possible. I called all the hospital and clinic necessary immediately. Thus, on February 7th, 2019. 2 days later, managed to get appointment in a hospital in New York. He was diagnosed as PI hydronosis in Weill Cornell Hospital. The neurologist, urologist, and radiologist together recommended a test named VCUG to him. I paid out of pocket for all the tests, and we signed the lease agreement in New York on February 26, 2019, and living in New York since then. On March 1st, the urologist assigned the test to Haoxuan and made the diagnosis of UTI. After the test, my son urinated blood, and followed by several appointments by the doctors. And 2 weeks later, on March 15th, 2019, I received telephone calls and emails from the hospital and the doctors and requested me for another appointment with my son Haoxuan. And I mentioned about I'm thinking about second opinion since as 2 weeks has already passed and nothing changed. And but I still agreed with appointment on March 21st, 2019. Then the same day, on March 15th, 2019, both New Jersey and New York, because previously we live in New Jersey, and the first UTI diagnosis was made in New Jersey, and because of the urgent of the doctor's referral, I called all the hospital and finally got the appointment in New York. That's why we moved from New Jersey to New York and began to live in New York. And the same day, on March 15th, after I mentioned about the second opinion, both New Jersey and New York Child Protective Agency received a report from the hospital staff that they concerned about Haoxuan being educational neglect. So on March 15th, 2019, it's 8:20 p.m., a late Friday night. Haoxuan was having dumpling soup together with family members at home. ACS New York's caseworker came directly to my apartment, intend to tear up my son's passport and medical records, and use ambulance for all my family members, me, my parents, and my son, went to Weill Cornell Hospital. And my family members were locked in the hospital room from March 15th, 2019 to March 18th, 2019, 8 p.m., with securities changed every 8 hours. So according to the petition and the court transcript, on March 18, 2019, the hospital reported to ACS and Family Court New York. They found a child abandoned in hospital, nationality unknown, and parents unknown. The agency also confirmed that there is no effort being made before the child fostered to a hospital. The accused to me changed from educational neglect to abandon and addressed to medical neglect. So Haoxuan is not a neglected child, now abandoned child in hospital, should not be kept in foster care. ACS confirmed Haoxuan was diagnosed with mild swelling of the kidney, SP1 hydronosis. See Child Attorney's Brief, page 3. It's line 19 to line 21. But on the doctor's notes, it's actually listed Haoxuan has PI hydronosis on left kidney, and the right kidney is well normal. Mild swelling is still swelling of the kidney, and PI hydronosis is still hydronosis. The law and the reasonable person will not expect a parent to ignore such.
Thank you. Actually, your time is up, but I'll give you 1 minute in rebuttal after the attorney for ACS speaks.
Okay, thanks, Your Honor.
You're quite welcome.
Good morning to the court. Assistant Corporation Counsel Deborah Wassell on behalf of the Administration for Children's Services.
Before you get started, I have a question. I didn't recall reading anything in the papers about abandonment as being one of the, I guess, allegations or charges against the petitioner. Was that something? She talked about some indication of abandonment at the hospital. I don't recall seeing that.
That's correct, Your Honor. That's not in the papers. It's not one of the bases for the neglect petition.
Okay. So the neglect petition was solely based upon medical issues.
That's correct. The mother is alleged to have subjected her child to many unnecessary medical procedures She provided no medical evidence for, for any of the various diseases she claimed her child had. And when she was told by various doctors who examined her child that the child was healthy, she continued to take him to other doctors. But I do want to just remind the court that that's not actually what this appeal is about. It's about the dismissal of the petition under 1051, and the elements of that claim have clearly not been made out. The aid of the court is very clearly needed in this situation, and so the family court properly declined to dismiss the case for those reasons. It was in the middle of the fact-finding at the time that the mother made the motion to dismiss.
How long has this fact-finding been going on? I understand we're going through COVID. I have some concern about the length of this.
So ACS has presented all of its evidence and is essentially has rested.
So what's left at this point?
I don't have a record on that, Your Honor. The mother has made several interim applications, which the court has had to deal with, but ACS has presented its case.
But is the evidentiary phase over at this point? I understand it's premature to dismiss, but is the evidentiary phase over?
ACS has presented its evidence. It's unclear what appellant is planning to do at the hearing. I don't have a record on that, unfortunately. I do have an update. I spoke to the attorney for the child yesterday who was unable to be here today. If the court would like an update on the child, I can provide that. The child is doing well in foster care. He sees an English-speaking therapist. That was done over the mother's objection. We had to obtain a court override. He's currently on a waiting list for a Mandarin-speaking therapist, but he's doing well in the foster home. He went to summer camp. He's getting piano lessons. He's very affectionate with his foster family. He's doing quite well there. The mother enjoys supervised visits at the agency. There have been no major incidents so far, but she has not engaged in any services, including any mental health services or a mental health screening. If there are no other questions from the court, ACS will rest on its brief. Thank you.
Thank you. Yes, you have 1 minute.
Thanks, Your Honor. So, as ACS confirms that Haotian has mild swelling of the left kidney, it's still swelling of the kidney, and PY hydronosis is still hydronosis. First thing, the law and the reasonable person will not expect the parent ignore such diagnosis or waiting. And the VCUG test is actually confirmed from the urologist and cardiologist and radiologist together in Weill Cornell Hospital. After Haotian being removed to foster care, actually he was taken away from the hospital with only a text to me, I have your son. And I have no information about him for over like 10 days. With a lot of efforts from the court and from the ACS system as they changed his name in the system. I cannot get any information from him. So 10 days after, the efforts from the court, I finally got a chance to visit him. And since Haotian was kept in foster care, may I?
Yes, just finish that thought. Just finish that part.
Oh, okay. So after Haotian being moved to foster care, the agency called 8 times police enforcement in Queens and 2 times in Manhattan.
Thank you. Thank you very much.
Thanks.
Wilson versus Christ Alive. Did you want to argue from there?
I do, I just know.
Yeah, please, at the podium. Yeah, everybody, we're going to argue from that podium. That's why it's there.
Yeah, I didn't know if Appellate was showing.
Yeah. Okay.
Good morning, Your Honors. This case involves allegations from the appellant that the respondents fraudulently induced a 10% tithe for her from a settlement that she received from a personal injury action. She claims that she wanted to tithe on the 10% of the annuity, not the net settlement that the respondent passed her.
So is this a justiciable controversy?
No, Your Honor, it's not a justiciable controversy. As found by the lower court, there's no way you can analyze whether you should tithe on this amount or that amount with getting into interpretation of religious doctrine, which the courts are forbidden to do by way of the free exercise clause of the First Amendment.
Are all of her courses of action in the complaint, they all stem from that $230,000 payment that she made?
Yes, Your Honor, the 4 causes of action, or, well, I guess technically the emotional distress action is associated with, it's a byproduct of the 230. The other ones are for fraud, constructive fraud, and breach of I'm sorry, a constructive trust. The court did dismiss all of them, and even if this court found this matter was justiciable, as outlined in my brief, there's no material misrepresentation. The plaintiff herself acknowledged at her deposition when I asked her, can you point to something that was misrepresented? No. Can you point to some undue influence? No. Can you point to some coercion? No. She just said, in hindsight, now that I left the church 5 years ago because we had a falling out, I think I'd rather have tithed on the annuity as opposed to the net settlement amount, naturally reducing the amount she ultimately tithed. But she never made any complaint about the tithe prior to leaving the church. It wasn't until 5 years after she left the church that an attorney said that it was inappropriate, not fraudulently induced, but inappropriate. And then she couldn't identify any fraud at the deposition. And as I said, she just regretted and would like to have tithed on the annuity as opposed to the net settlement amount.
But the bottom line is we're talking about tithing to the church, which is purely religious doctrine.
Precisely, Your Honor, yes.
There was no contract or any oral or written agreement.
Correct, Your Honor. It's purely whether or not, exactly as Your Honor put, whether or not this court can pass judgment on whether she should have tithed on X or should have tithed on Y, which, although New York courts have visited this issue, the cases cited in my brief show that sister jurisdictions have uniformly and resoundingly said, you cannot pass judgment on whether a parishioner should have tithed on X or should have tithed on Y. And they are laid out in my brief. They say that such a judgment would be a purely ecclesiastic matter. And in the Tennessee appellate court case, the court found the resolution of the issues would require us to examine the question and the legitimacy of the defendant church there's dogma and doctrine. This is a forbidden domain which we will not enter, citing to the United States Supreme Court of United States versus Ballard 322 U.S. 78. And the other court case that I rely upon heavily in my brief regarding the Louisiana appellate court's decision on tithing there, the plaintiff alleged that the church misled him to tithe on 10% of his gross receipts of his business. Court wouldn't visit jurisdiction on that. The court said any legal analysis would require this trial court to analyze and pass judgment upon teachings which would violate the neutral principles of law approach in order to see if there's justiciability. And the issue of tithing is, at its core, a purely ecclesiastic matter. And I also cite the subsequent case involving the same parties where they had similar issues. And the court commented one more time that no matter how you cloak it, fraud, coercion, undue influence, the controversy is purely religious and there's no jurisdiction.
Thank you, Counselor.
Thank you very much.
Flores versus New York City Transit Authority.
May it please the court, Tim O'Shaughnessy from Transit. The sole basis on which the court excluded the testimony of the bus driver was that his custom and practice was not under his complete control.
Right. So my understanding of custom and usage, right, or prior custom and practice, is that I don't remember exactly what I did in this particular situation. However, I know that in such a situation, I do X, Y, and Z. Is that basically what we're talking about? We're talking about custom and practice?
Yes, in all
So
such
now,
situations.
In this case, The bus driver stated, I don't even remember being in this situation. I don't remember, I have absolutely no recollection of seeing the plaintiff cyclist, seeing any cyclist, of hitting the cyclist, hearing anything or seeing anything. I don't remember anything about this accident. So how could custom and practice be introduced when he doesn't even remember being in that situation?
Well, because his testimony would reinforce his recollection that he did not see the bicyclist.
So
Furthermore,
but
his
that's,
testimony-
counsel, that's just exactly what my colleague is saying, Judge Weber is saying. If he doesn't remember it, how could he have had a practice? You only have a practice if you see the guy,
I
right?
understand.
So wouldn't that allow the jury to impermissibly speculate that he did something when he didn't even have the predicate for doing it?
Your Honor, I understand completely. I'm answering. He said what his customary practice included tooting his horn. The plaintiff said, I never heard a horn. This would, the jury could infer from this that it supports the bus driver's testimony that he never saw the plaintiff. Transit's attorney argued as follows in his summation. We don't have a bus video. We don't have any witnesses to the contact. Plaintiff stated he was riding on the right side toward the curb from this white line between the travel lane and the parking lane. And plaintiff also said that just before the contact, there was no car in the parking lane, and so he kind of swerved to the right. So Transit's attorney argued, well, maybe when he swerved back to go around the car that he was coming up to, he messed up and went too far and hit the bus.
But counsel, I know your time is up, but also the custom and practice of tooting or honking his horn was also when he approached when he would blow his horn whenever he approached or was about to overtake a cyclist. Again, his testimony was he never saw plaintiff. He never saw a cyclist.
But if he had been permitted to testify, the jury could infer from the fact that he did not toot his horn, which the plaintiff testified to, that he did not see the cyclist. The plaintiff was not where he said he was.
Right, and that would be an impermissible inference, as Justice Scarpullo just mentioned, because what you would be trying to do is prove a negative. Obviously, because plaintiff never heard the tooting of the horn, for some reason that meant that plaintiff actually was not near the bus, which was your other argument, was that this never actually occurred, right?
Well,
he never actually struck plaintiff
the plaintiff's credibility, of course, is in question. There was no witness. The witness just saw the plaintiff go head over heels, did not see how the
Right, there was a witness. There was an independent witness who did see the plaintiff all of a sudden,
Yes, well, there's no question there was an accident. But
Right.
He didn't say exactly how it happened. And the fact is, it's just not, it's not credible that the plaintiff was on the right-hand side of that white line and the front of the bus passed him without hitting him, but the back of the bus passed
an
him.
accordion bus.
And you didn't even argue that. You didn't argue that on appeal. You didn't say to us that this isn't supported by the weight of the evidence. You argued an evidentiary point, which is completely different.
No, but what I'm saying is this evidentiary point is very important because if that had been before the jury might have decided that the plaintiff had not moved that ball over the 50-yard line to prevail by the preponderance.
But
I
you
just
didn't
don't see
present
how
any
you could do it.
testimony from the bus driver that would even insinuate such an occurrence. Bus driver said, bus driver just said, I don't know. I was driving a bus. I stopped at 75th and 2nd, and somebody said, that cyclist had been hit. I didn't see the cyclist. I don't know what happened.
It's true. Well, he's being honest. He didn't see the cyclist.
And that's why perhaps the jury rendered the verdict that it did. Thank you, Counselor.
That's right. Thank you.
Yeah, okay. Let's see, we have 830 Global, 830 8th Avenue versus Global at 8. Oh, right.
May it please the court, my name is Stephen Sperber. I am thrilled to have the opportunity to appear in person before your honors. This appeal involves a denial of a summary judgment based on a unraised non-issue of fact.
Mr. Sperber, let's discuss the original affidavit of your client. Why do you believe it was sufficiently authenticated?
The original affidavit, Your Honor, said that the proponent of the affidavit was the principal, the managing member of the petitioner, and that he was familiar with the facts and
So it was made on
circumstances,
personal
and this was the lease and this was the guarantee. Your Honor, but equally important, in the verified pleadings, which are part of the record and found at page 92 of the record, paragraph 5 of the complaint refers to the lease, paragraph 8 of the complaint refers to the guarantee. And if you turn to R112, these are both admitted in the pleadings. The defendant admits the lease and admits the guarantee. To take it a step further, at R154, in his affidavit in opposition to my motion for summary judgment, he refers to the lease and the guarantee. The opponent says, as set forth in my lease and my guarantee, as annexed to the moving papers. In the termination notice, which is found in R157, he refers to his lease. And finally, it's not denied. Nowhere is there an issue of fact raised about this point. And to take it a step further, Your Honor, in our motion to re-argue, we just clarified the one thing that I don't think it was an error, but he said this is a business record made and kept in the ordinary course of business. That was the only change that we made. Nowhere was this raised. There were 3 affirmative defenses. There was an admission in the pleadings.
So counsel, there was never any allegation in the lawsuit that this wasn't the binding agreement?
Nowhere. In fact, as I just stated, 5 times he admitted it. He admitted in the pleadings. He admitted in his affidavit in opposition. He admitted when he terminated the lease. All of this, what he said instead as his defense was that we should get a credit. We shouldn't have to pay June because we moved out in the middle of June, and we shouldn't have to pay
Can
July.
you address that issue with respect to surrender, please?
I'm sorry, Your Honor.
Can you address the issue with respect to surrender of the premises?
The surrender doesn't terminate liability, Your Honor. When they surrendered 21 of the 22 units. There was 1 unit that they said was not surrendered. When my client took back this building, it was a net lease, they went there and they found that this 1 apartment was open. So they changed the locks. The tenant's son obtained an order to show cause in a lockout proceeding, and we appeared before Justice Essaforis below, and she ruled in the landlord's favor and said that he had no standing, but it took until July 20th until she did that. And so if there's no questions, on this record, a judgment should be entered in the sum of $297,196. If the security comes up as an issue, it was credited. If you look at the rent history, which we've annexed to our moving papers, even though it didn't have to be, because a guarantor is unconditional and the guarantor didn't even put up the security. Thank you.
Thank you.
Good morning. May it please the court. While Mr. Sperber refers to the lease and the guarantee and claims that it was omitted in the answer and in various other places.
Counsel, in the motion for summary judgment, what position did you take with respect to the lease and guarantee?
That's a good question, Your Honor. So we utilized the lease that was attached to the papers for the sake of the motion. We did not acknowledge that that lease was the true and original lease.
Did you raise any issues with respect to authenticity of the lease in your papers on summary judgment?
No, we did not. But nonetheless, Your Honor, if I may proceed.
Sure.
There are plenty of other issues in this case that clearly make it not ripe for summary judgment, even if you take the lease aside. Um,
So in this case, what was the vacate date? What was your client's vacate date?
Well, that's a very good question, and it's not borne out by the facts of this case in any way, shape, or form. The fact is, we gave back 21 out of 22 units on June 5th, and that's in page 4 of the appellant's brief.
But what does the lease require? Doesn't it require surrender of all persons and entities who are claiming rights to occupy the premises? So when did that occur, ultimately?
Again, that's a very good question. We know, Judge, due to a subsequent case, not subsequent, call it a companion case, at a legal lockout in landlord-tenant court, of which the plaintiff appellant was not a party of. They were attempted to be brought into the case, they never were. In that case, it turned out that the plaintiff appellant took back that apartment. They changed the locks, they didn't deny it, they took it back. To this very day, Your Honor, they refused to tell us what day this happened. They refused to say what day they actually took it back. Now, we haven't had the benefit of discovery, as Your Honor well knows. And they are playing extremely coy as to when they took it back. You could look through the entire history, all the papers that are submitted here, you will not find the plaintiff appellant coming clean and telling this court
But when would they have
took it back.
gotten legal, when would they have gotten legal possession? Wouldn't they have gotten legal possession once the court ruled that the holdover tenant didn't really have the right to occupy the premises?
We never got to that point. They've admitted they've taken it back. That's not denied. Much as the way Your Honor has pointed out that we did deny the lease and the guarantee, they have not denied they took back possession of the premises. In fact, it's tacitly admitted in their complaint as to the date they cut off their damages. But again, what date, Judge, we don't know. There's been no discovery. They've had ample opportunity on numerous affidavits in more than one proceeding, and they refused to tell us when they took it back.
What was the July 21, 2020 date? Wasn't that the date that the rights were terminated?
I don't believe so, Judge.
September 30th,
September 30th, I'm sorry, September 30th, right?
So in the reason this gets
September
confusing is
30th.
we haven't had discovery. So in
Do you need discovery to know the date of September 30th?
no, but that date doesn't relate to when the plaintiff appellant took back the apartment. They don't even ask for, Your Honor, they don't even ask for monies through September 30th because they know they took it back. Why wouldn't they ask for money through September 30th if they had not taken it back? We're all in a cloud here because they refuse to come clean.
Anything else?
Yes, Your Honor. The point about the security that Mr. Sperber brought up, it was credited, but it was credited not in the month that we deemed it or the month that we requested it be credited. He's crediting it to the side of the tenant rather than to the guarantor, or really rather to April 2020 or May 2020, in which it should have been credited. It's clear, Your Honor, that if you look at the record, I have my notes right here. There's a May 12th, 2020 letter. It's page 171 of the record. There is a letter written by the defendant in which we asked the plaintiff appellant to apply our security to the arrears. So what they did was very cute. Instead of applying it to the arrears, they apply it to a future date which accrues to the tenant and not to the guarantor. So in essence, yes, we did get credit, but not to the guarantor, which is where the real argument is.
Thank you, Counselor.
Thank you.
Your Honors, my reply can be found at page 154 of the brief. Abraham Roskam, being duly sworn, deposes and says, paragraph 1, I'm fully familiar with the facts and circumstances. Paragraph 3, the instant controversy involves defendant Global at 8's lease of 21 apartments and a guarantee.
No, yeah, let's move on from the idea that somehow this lease wasn't. I want to ask you, why is July 21 the vacate date?
Because there was a stay of the landlord doing anything
That's what I thought.
with
The
the
tenant was
apartment
put back
until
in,
that
right?
day, because Judge Asaforis had issued a stay, and when she released the stay, and in fact, Judge, I think that my adversary raises a red herring. We do have damages through September, but I didn't choose to move for summary judgment on that because then they probably would be entitled to discovery. Was it re-rented? When was it re-rented? That kind of issue. There was no issue of fact through July 30th, and that's why I strategically only moved for summary judgment through that date.
July 21 or July 21?
July 21, I'm sorry. I keep
okay.
saying July 20th.
Yeah.
And that's the day that the housing court dismissed the petition, correct?
Yes, Your Honor, yes.
Right, that's
Okay,
the July
got it.
21 date. Okay, fine. Now, what about your adversary just said the monies were put towards the tenant and not the guarantor?
Again, a non-issue. The security deposit, if you read the guarantee says one of the things you have to do is pay all the rent through the date of vacatur. They didn't pay the rent. So on the guarantee, they're liable all the way to the end for all my damages. The guarantor wouldn't have the benefit of the security
So
anyway.
you're arguing that that would not in any way affect your damages? Your
Not
cost
in the
damages.
least. But we gave them the credit anyway, just to make the motion easy for the court below.
Thank you.
Thank you.
Ayala versus the City of New York. What are you doing?
Good afternoon, Your Honors, and may it please the Court. Ben Pollock for the Appellate City of New York. The city was entitled to summary judgment under the Storm in Progress Doctrine for two reasons. First, the city established its prima facie entitlement to summary judgment by submitting certified climatological records showing that it was snowing at the time of the fall. Second, plaintiff failed to submit any evidence in support of her speculative theory that she slipped on old ice from a prior snowfall. Now, under CPLR 4528, records taken under the direction of the Federal Weather Bureau are prima facie evidence of weather conditions. The city submitted such records. Plaintiff failed to submit any records that were certified. Instead, plaintiff submitted a printout that was uncertified from a website, the Weather Underground or wonderground.com, that purportedly showed that it did not begin to snow until half an hour after her fall. Now, not only is this record, are these records inadmissible and not competent evidence under the CPLR and the precedents of this court, but they're also contradicted by plaintiff's own testimony. Now, plaintiff testified that it had been snowing prior to her fall on the day of the accident. She said, and these are direct quotes from the record, it had been icy outside, it had been snowing that day, and it was a bad day. Plaintiff points to her testimony that there was snow piled next to the sidewalk where she fell. And she also asserts on appeal that she had testified that there was no snow accumulated on the sidewalk where she fell. However, plaintiff never so testified. She never testified that there was no snow on the ground where she fell. And in fact, in her 50H hearing, she was asked, and again, this is a direct quote, whether there was, quote, any accumulated snow on the ground, and she simply answered yes. This court has found that purely speculative arguments such as this one are insufficient to raise a triable issue of fact. Plaintiff never testified that the ice that she allegedly slipped on was dirty or discolored, or that in any way it appeared old. In fact, she never testified, as she frankly admitted, that she didn't remember seeing snow piled on the ground, piled next to the sidewalk, or ice on the sidewalk in any of the days preceding her fall. The only evidence, the only putative evidence that she submits are these inadmissible and uncertified website printouts, and also the testimony about piled snow. Under this court's precedent, this is simply insufficient to raise a triable issue of fact. Now, on appeal for the first time, plaintiff presents her only evidence whatsoever of any prior snowfall before the day of the accident. And that evidence is, in fact, the certified climatological records that the city submitted. Those records show that it snowed approximately 0.1 inches over the 9 days preceding her fall. As a matter of common sense, that just doesn't seem sufficient to create these snowbanks piled next to the sidewalk that she points to. And in fact, that evidence is consistent with the city's argument that a storm was in progress. We know that it snowed approximately 1.4 inches on the day of the fall. And her testimony, plaintiff's testimony about piled snow simply confirms that theory. I would point out as well that this only evidence in support of plaintiff's speculative theory of prior snowfall, pointing again to the city's certified climatological records.
So counsel, you're saying that there was no, that wasn't raised below. She didn't argue, she didn't, in her notice of claim, say that the city had exacerbated the snowy condition by not shoveling correctly. That was not something that she put in her notice of claim, correct?
I don't, trying to think back, Your Honor. I don't believe she raised that. She certainly did not raise that argument in opposition.
She didn't argue it in opposition.
Pardon me?
She didn't argue it in her motion for summary judgment. That was not part of her
That's
claim.
correct, Your Honor. She never made that argument, and she also, Your Honor, did not make an argument that it had snowed earlier in the day, stopped snowing, and that a reasonable time had elapsed, which would have been consistent with her sworn testimony. She never made either of those arguments.
She said
in
it was
opposition.
raining, didn't she not? Did she say it was raining?
She had some inconsistent testimony. I believe she said it was raining, it was a nasty day. She also said it had been snowing before, and she also testified that she couldn't recall whether it was still snowing at the time of her fall. If there are no further questions, I'll reserve the remainder of my time.
Thank you.
Thank you.
May I proceed?
Please.
May it please the court, my name is Daniel Wright from Burns & Harris on behalf of plaintiff respondent. I respectfully request that you affirm the decision of the Supreme Court denying their motion for summary judgment on specific issues of plaintiff's snow and ice related claims. The defendant here...
Would you agree that the evidence submitted by the defendant, the weather report that they submitted, the certified weather report, that proved that at the time of your client's accident, according to that report, it was snowing?
No, Your Honor. We assert that their weather report is from Central Park. This accident occurred in the Bronx. The weather data that we provided, although uncertified, was from the Botanical Gardens location.
But how can we consider an uncertified weather report?
Your Honor, there's a long-standing history of the court giving judicial notice, as the Supreme Court did below, of weather data as we submitted. Also, hearsay evidence with supported deposition testimony, as the plaintiff provided in this case, is sufficient to support the weather data that we provided.
Are there no certified weather reports for the Bronx?
At the time, there was no National Climactic Data Center weather station in the Bronx.
And so the Weather Underground website, I believe also there have been issues with that website in terms of its reliability?
I'm not aware of any issues at the present.
So counsel, are you saying that your client's testimony was consistent about whether it was snowing?
I'm saying that...
You're saying that she essentially corroborated the uncertified report from Weather Underground. But, I mean, I read her testimony. She was all over the place. She said it was snowing, it was raining, it wasn't, it was dry, it was hot, it was cold, it was green, purple, and red. Her testimony clearly didn't corroborate that.
Well, as you're aware, the entire argument that the defendant is resting on is one page out of a 44-page deposition testimony of
No, she
testimony
was
related.
all over the place. I mean, the deposition testimony was, it was raining, it was a nasty day, it wasn't snowing, it could have been snowing, there was snow there wasn't any snow there. She said several different things, for sure.
Correct, Your Honor, but she clearly stated that there was piles of snow on the side of her, and she clearly stated that there was an icy condition in the walkway that she slipped on. And defendants, in this one page of deposition testimony where they questioned her about the snow conditions, the sidewalk conditions, they failed to elicit any clear testimony regarding the snowfall and the conditions of the sidewalk in that one page.
So if we assume, for example, that a certified climatological record, which we have held many, many times, is sufficient to meet a prima facie burden. So the defendants met their prima facie. And now it's your turn to do something in opposition. You have one, an uncertified hearsay document, and two, deposition testimony that's all over the place. How do you raise an issue of fact in that circumstance?
Well, as the Supreme Court found, we believe that our record that is closer in location to where the accident was will show a clearer view of the conditions in that area compared to their certified record. And it's our assertion that her testimony, although, as you allege, all over the
No, I don't allege it. It is what it is.
all over the place, is clear about the icy condition, which is the important issue, and the snow piled on the sides of the sidewalk.
But wouldn't that be consistent with a storm in progress? It's icy because it's snowing. It's icy and slippery because it's snowing at the time she falls. So that doesn't raise an issue of fact.
She never stated that it was snowing at the time. She felt she couldn't recall, and defendants failed to elicit out of her testimony specifically whether it was snowing or not.
So it was snowing, it would equally be consistent with a certified climatological record that it was snowing in that period of time, which is the snow in progress doctrine. That's what we're talking about, right? It doesn't have to be snowing that second, correct?
Correct, in Central Park, where that weather station collected the data, not in the Bronx, where this accident occurred. If there are no further questions, I'll rest on the rest of my brief.
Thank you.
Thank you.
Your Honors, we'll waive rebuttal and just ask that you reverse in relevant part and grant summary judgment for the city unless there are further questions.
No, thank you very much.
Thank you very much.
Silver Point versus Riviera Resources.
May I proceed, Your Honor?
Please.
Your Honors, good morning. May it please the Court, I'm Joshua Liston of Bays, Liston, and Mabarga, here to argue on behalf of plaintiffs' appellants, the two Silver Point entities. There can be no doubt that the amended complaint in this case adequately pleads that Riviera engaged in criminal insider trading in violation of both federal and state law. Your Honors knows the facts here, that Riviera approached Silver Point in order to get Silver Point to sell 1.7 million shares back to Riviera, and they entered in an agreement to do so on August 6th,
Counsel,
2019.
have you raised in your complaint any sort of federal securities claims?
No, Your Honor, we haven't.
So then why would, you premise your argument on, I guess, these securities violations. Why would we even consider that?
Sure, Your Honor. It's important for several reasons that go to the heart of the case, because the court below fundamentally misunderstood the role that the federal securities laws plays with respect to the state law claims that we brought, and with respect to the defenses that prevailed below. Most important of these is the Riviera's unwaivable duty to either disclose MNPI or to abstain from trading. You may recall from looking at the decision below, possibly also the oral argument transcript, that the court below was very focused actually on permitting Riviera to make this trade because it felt incorrectly that Riviera had no ability to disclose this information to Silver Point. And that's simply not true. And that's the primary reason we raise the background.
But, you know, the elephant in the room is the agreement you folks signed. I mean, it contains a release. It says that there is material information that they're not disclosing. So you're on notice. You're on notice that there may be information out there, yet your principals go ahead and execute the agreement.
Yes, Your Honor, we are on notice that there may be certain information, but then let's draw it into what kind of clear New York law is on those subjects. And I'll start with the release, which I know the court below found is the primary driver of its decisions. And there's at least 4 reasons why that release does not bar these claims. The first, we touched upon it briefly, it's the illegality of the release itself, and it's not just Section 29A under the federal securities law, under the Exchange Act. It's also under companion New York law that says that attempts by a party here, such as Riviera, to put in a release that absolves it of its own criminal conduct, and we cite cases where the failure to provide inside information of this character is a crime under New York law, that New York law would put aside that waiver.
But how could it be a crime under these circumstances where your principals know that there is information that's not being disclosed?
Sure, but they don't know what the information is. And obviously here, as pled, the information is of blockbuster material character.
Counsel, has the defendant been charged?
No, Your Honor.
Has the SEC raised any issues?
Not that I'm aware of, Your
So
Honor.
nobody but you thinks that this is a crime, correct?
I would disagree with that.
I mean, obviously, if somebody else thought it was a crime, there'd be an investigation, there'd be an SEC complaint, there'd be the Southern District would be all over it. None of that happened, correct?
Not to my knowledge, Your Honor.
Okay.
I will say, as is obvious, that not every crime gets investigated.
Oh, no. A crime like something like this would have caught the SEC's attention. I'm just saying that's your allegation, but there's nothing behind it. There's no factual basis for it except your belief.
Your Honor, respectfully, I think just the mere fact of failure to disclose information, it's a federal securities law violation.
It is not.
Sir, you're not even claiming a securities violation, so I don't understand why we're going down that road.
Let me bring it then to the claims that we've actually pled. And I started with illegality. There is New York law on the subject, but let me turn it to the specifics of the adequacy of the release here, right? And here I'd focus on, in this case, irrespective of federal law, which I do think is helpful background in what they're required to disclose. But the 3 things to focus on. So first, let's focus on, under clearly established New York law, that when 2 parties who start in a fiduciary relationship, which happened here, you have a company and a shareholder starting to have a conversation about a transaction. Are there fiduciary duties? Unquestionably, the answer is yes.
But can that duty be waived?
That duty can be waived.
And was it waived under the agreement?
No, Your Honor. And let me explain why. And this is very clear to us under the First Department's opinion in De Benedictis v. Malta, which sets forth 2 extremely clear prongs, both of which have to be satisfied before a court will find that the fiduciary no longer has any obligation to its principal in that transaction. And in De Benedictis, the first prong is a broad general release or a release of all fiduciary claims, okay, neither of which happened here. I think it's undisputed that the release here is a limited release. We can talk about the scope of it, but it is a limited release. It doesn't release all claims under the sun. It doesn't even release all non-disclosure claims. It's also not a release of all fiduciary claims. So that prong is not satisfied. So that alone means that Silver Point did not waive the fiduciary duty that Riviera owed to it. The second prong is that there also has to be no longer a relationship of trust. So what Riviera has said is essentially Silver Point's sophisticated, and this was the end of the relationship. But no court, as far as I can tell, has ever found either of those to be sufficient.
We have ruled, this department has ruled that if it's an arm's length business transaction wherein the release is negotiated, then the fact that there was a fiduciary relationship, that fiduciary relationship does not invalidate that release.
I respectfully disagree with that reading, and let me give an example of it. I mean, de Benedictis.
You disagree with the reading of our cases that say that?
Yes, Your Honor, because I think both things are required. I see my time is up. If I may have a few seconds to finish.
No, you have time on rebuttal, though.
Fair enough. Thank you.
Thank you.
Thank you, Your Honors. May it please the court, Stephen Atkinson from Kirkland & Ellis on behalf of Riviera Resources. This is a contract case controlled by a clear and unequivocal agreement signed by Silver Point's most senior litigation counsel on Silver Point letterhead.
So counsel, isn't this whole letter agreement exactly the reason why you enter into one of these letter agreements is to not have this litigation right here? That is the sole purpose of not having this litigation, is you're saying, because there is law that, fraud could be an omission or a commission and this and that. So you execute two big, important, people who know what they're doing. Well, I don't know if they're big and important, but they know what they're doing, right? And they say, we want to make sure that that law doesn't apply here. So let's sign this agreement. I'm telling you, I'm not disclosing everything. You know that I'm not disclosing everything. We both agree that that's okay. I take the risk.
Sorry, Your Honor.
That's what the agreement says, right?
That's absolutely right, Your Honor.
They took the risk, it didn't work out for them, and the lawsuit followed.
That's right, and it's not like they claim they didn't read it. It's not like they claim they didn't understand it.
But they
say
do
in their
claim that there was a fiduciary duty. So
we
what
do
about
not
that?
dispute that absent the waiver in the big boy letter, my client, the directors and officers of my client, were bound by fiduciary duties. We do not dispute that, but counsel reflects on this de Benedictis case,
right,
and says that we don't meet the first prong because this is not a broad general release or an express waiver of fiduciary duties. That's false. There is an express release of all fiduciary duty claims in Section 6 of the big boy letter here. With respect to whether our client was able to waive fiduciary duties, Your Honor, you raised correctly that there is a long line of case law in this department that says there does not need to have been a prior dispute among the parties in order for sophisticated multi-billion-dollar hedge funds to agree to waivers of fiduciary duties. All that needs to occur, and this is the CAFA case, this is the Shilpa case, this is the Chadha case, there are others. All that has to occur is that the parties be at arm's length, and in some cases there's a suggestion that the negotiations have to be for the termination of the parties' relationship. Of course, we have here the termination of the relationship. Our client, my client, was buying back the shares from Mr. Liston's client. And again, as Justice Scarpula said, there was nothing unusual or confusing about this quote-unquote big boy letter.
Yeah, could we not call it that? Let's call it something else.
Sure, we'll call it the release.
The release.
The release.
But you did have special facts, right? And your adversary contends these facts weren't available outside, and that they should have an opportunity through discovery to establish, in fact, that you knew about it and you fraudulently induced them into entering this agreement.
So, yes, Your Honor, that is the allegation. The special facts doctrine, it's clear under New York law, applies only when the facts could not have been discovered through ordinary diligence.
Well, how would they have discovered these facts?
They could have asked. Riviera had announced four prior asset sales in the 12 months preceding this.
Had they specifically asked, you would have told them that the sale was pending?
My expectation is, I don't know, I can't answer the counterfactual, I wasn't at the table, Your Honor, but my expectation is if they had asked, we would have said, we're not telling you, and they then would have had the decision as to whether to proceed. We had done this is in the plaintiff's complaint, we had done 4 asset sales in the last year. We had announced multiple times in the year leading up to this that we had 3 corporate objectives. One of them was asset monetization. We were openly selling assets, and
but different assets, correct?
Not this precise asset, of course, but you would think.
But doesn't all that go, if that's your best argument, doesn't that really go to issues with respect to discovery?
Well, no, I mean, first of all, Your Honor, that's not the best argument. That's one argument. And I don't believe it goes to discovery because I think no reasonable finder of fact could conclude that this was outside the scope of something they could ask for. There's a reference to this duty to inquire, particularly that sophisticated parties are held to, and they didn't ask a single question about this, which is kind of unusual, I would think, when you're, selling your stock back.
But bottom line, the special facts doctrine you say was released by Section 6, correct?
I'm sorry, the fiduciary duties fiduciary duty claims, disclosure claims, et cetera, were released by the.
But how about with respect to special facts? How does that tie in?
Well, so I think the way the doctrine works is if the special facts doctrine applies, then the release or the waiver is not effective. Our argument is the special facts doctrine is satisfied, but I want to get back to, Your Honor mentioned my best argument. My best argument is that the special facts doctrine does not apply to releases. This court held that in the Centro case, First Department. It was affirmed by the New York Court of Appeals. This court distinguished the Blue Chip case. The Blue Chip case had held that the special facts doctrine applied to releases, and the court said, we disagree. Blue Chip is not good law because I'm sorry, I misspoke. Blue Chip applied the special facts doctrine to disclaimers, and this court in the Centro case said Blue Chip does not apply to releases. Releases may be, you may be excused from a release for the traditional contract reasons, duress, fraud, etc. The special facts doctrine applies to disclaimers of reliance, as this court has held, as the ACIM court case that we cited in our briefs also has held. So special facts is off the table. And when counsel cites cases like basis yield, which do not have releases, they're simply inapposite. So our best argument, Your Honor, for why special facts is irrelevant here is that this is a release and not a disclaimer of reliance. Secondarily, to be clear, our view is as a matter of law, there was a duty to inquire, given all that was out there, both publicly from us and in the trade press. This is a multi-billion-dollar hedge fund doing a multi-million-dollar transaction. They don't ask a single question. They take the release letter, they put it on silver point letterhead, they have it signed by their chief counsel, and now they ask Your Honors to bail them out. Under the law, and to be clear, they are asking this court to overrule or depart from decades of precedent. And this federal securities waiver claim that we're hearing, by the way, for the first time on appeal, would throw, I mean, if this were right, Your Honors, and I don't want to dwell on it, I mean, they don't even bring federal securities claims. If this were right, then Pappas would be wrong, New York Court of Appeals. Centro, this court, and New York Court of Appeals would be wrong. Harborview, federal court decision, would be wrong. Harsco would be wrong. I mean, there's a reason, I would say, that, Your Honor, that this was not raised before the sort of Hail Mary that they're presenting to this court. I'll also say, just to remind the court sort of what this letter said, it talks about information, right? It defines information, and it says that my client will not be disclosing this information. Information is defined to include anything about Riviera or Riviera's properties, Riviera's assets, Riviera's plans, and Riviera's prospects. To say that a plan to sell Riviera's assets and properties does not fall within the contract, which is what Silver Point argues, is simply inconsistent with the language. The letter further explains that any non-disclosed material non-public information, quote, could be indicative of a value of the common stock that is substantially different than the purchase price reflected in the purchase. That's section 1. First page of a 2.5-page agreement says that. Counsel, I just heard counsel say that this didn't cover blockbuster information. It says material. It says that it could substantially affect the stock price. Again, this is a massive departure from the letter that Silver Point's most senior litigator signed knowingly. They also say that they are, quote, experienced, sophisticated, and knowledgeable in trading in securities, that they understood, this is critical, they understood the disadvantage produced by the information disparity. They understood that we had information they did not have, and they said in writing that they understood that. They understood that they were capable of protecting their own interests, and that they still wished to enter into the proposed transaction. This was an arm's length transaction among sophisticated players. Silver Point is not happy with the deal they struck. They didn't ask a single question about asset sales, and I see my time is up. Thank you, Your Honors.
Thank you.
Thank you, Your Honors. I want to briefly hit a couple of points and then finish on the fiduciary duty issue, which I think is actually quite clearly in our favor. But first, Justice Singh, you asked questions about the special facts doctrine. The Court of Appeals in Centro embraced the special facts doctrine as a possible way in which a release can be undone. It just happened that in that case, the special facts doctrine was held not to.
But it's kind of funny because the letter agreement essentially suggests that they have special facts, and the point is that you've got a duty to inquire. You can say, hey, what is this material information that's going to affect the stock price that you don't wish to disclose?
So, and this is maybe it's a matter of pleading, but we did ask, why are we getting at the last minute this request for a big boy letter? And it was said because earnings were being released 2 days later that this language covers earnings. And look, is it somewhat ambiguous? Sure, but at pleading stage, the way Silver Point took that is the only information, this is a CYA on the part of Riviera, that the reason we're asking for this language is because we've got earnings coming out in 2 days, and we don't want a lawsuit following that. Now, on fiduciary duty, and this is the point, and this is where I was going with Your Honor's question prior to the time was up. Let me take specifically a case that Riviera cites in its brief for the proposition that as long as you have sophisticated parties represented by counsel, voila, fiduciary duties are gone. It's just not the case. And the case I want to point everyone to is Malta v. Gaudio, which Justice Singh dealt with below. And in there, Riviera cites this case basically for the proposition that sophisticated parties represented by counsel, that's it, no fiduciary duties. What they don't mention in their brief, but is very clear both in the court below and in the first appellate opinion that affirmed the case, was that there is a legitimate breakdown in actual trust. How do we know that? Because Justice Singh and the justices of this court on appeal said, the court likewise emphasized that, quote, Malta, a sophisticated principal represented by independent counsel, admitted in a separate action that he, quote, no longer trusted Gaudio at least 1 month before the sale's closing, and thus was able to, and did not release Gaudio from claims based on fiduciary duty. And the release here, it doesn't waive all fiduciary duties. Every bit of that release is conditioned by the second clause, which limits it not even to everything related to the transaction, but only certain non-disclosure
Had there not been a breakdown in the relationship?
No, not at all. Not at all. They were having a transaction. This is a publicly traded stock. Silver Point could have been in the next day.
Wait a second, counsel. Are you saying the only time that you can waive your fiduciary duty is when there's a breakdown? I don't accept that that's the correct statement of the law. I think what sophisticated parties do all the time is take a look at what the common law is in New York and say to themselves, we are going to contract out of that. They're perfectly free to do it. They do it all the time, including fiduciary duties, including duties to disclose. That's your problem here. You did all of that in this release, and you're entitled to do it. That's what we want. We want businesses to be able to do what they want to do, and you sign a letter that says, I'm releasing this, and now you're saying, but really I didn't, because there wasn't a breakdown in the trust between us. I don't think that that's the linchpin of releasing fiduciary duty.
Sure. I would just, Your Honor, De Benedictus points to these as conjunctive prongs, but even Your Honor, the first prong, which is about contracting out, says pretty clearly, and Silver Point is sophisticated. They know what the law is. They're not willy-nilly kind of giving up their rights. They're not bringing a claim based on earnings. They're bringing a claim based on information that Riviera's general counsel...
Does that release say anything about earnings?
Excuse me?
Does it say anything about earnings, the document you signed? Does it limit it to earnings?
No, it doesn't. It doesn't limit it to earnings, but that's a custom and usage argument. But Your Honor, there is no broad general release, which is one of the requirements under de benedictis, or a complete waiver of fiduciary duties. There just isn't in the contract. I understand that there's a view that Riviera said, we're not telling you anything, but that's not actually what the document says. It is defined in certain ways, and however that's read, as long as you believe, as long as you believe that not all of the fiduciary duties were waived, and just definitely that's true, even if we disagree about how much of them are waived, if you agree that any of the fiduciary duties remain, then First Department law compels the conclusion that at least at this stage, the decision must be reversed.
Thank you very much, Counselor.
Thank you.
People v. Hickcliffe Rosario.
Good morning, Your Honors. May it please the Court, my name is Susan Epstein, and I represent the appellant Hickcliffe Rosario. The complainant's text message, it's going to be hard to say text messages in a mask, but her text messages do not support her trial testimony. They do support appellant's version of events. There's two key text messages that show complainant acting on...
I'm sorry, is it limited just to text messages? Wasn't there testimony of the family? What was observed afterwards when they came out of the room?
Yes, and I'll tell you, this is what my argument, would like to focus on in this argument. Obviously you'll direct me elsewhere if you're not interested, but what I'd like to focus on is the text messages first and foremost, because they happened at the time the events occurred. They're contemporaneous. They're like excited utterances. They're like state of mind when it's happening. It's one part of the evidence. It precedes all the testimony.
But there's also there's other testimony too. So
there is, and what I'm trying to say, Your Honor, is that I think the jury was probably completely overwhelmed by all the witnesses in this case. There were 6 family members for the complainant testifying about 4 incidents. It was extensive and overwhelming, and in my mind, if you look at these 2 text messages in particular, they undermine the entire people's case.
And so you're referring to those text messages that led up to the incident. Is that correct?
Yes, I'm referring to text messages that led up to 2 incidents. And
right. You're not dealing with you're not addressing the incident itself as to what Justice Singh was just pointing to in terms of her actually being in the room, the other family members actually seeing her in the room, her statements when she ultimately left the room. You're only dealing with these 2 text messages days before.
That's what I would like to just begin with, if I may. And the first text message, these were messages where she shows she was acting on her own volition when she's supposed to be the victim. The first, she's describing when appellant tried to rape her and her mother was pounding on her front door. Afterwards, she texts her sister, "Once I heard mommy, I made my exit and closed the door." 2 months later, after telling police that appellant had threatened to kill her on the street, he gets arrested and she texts her friend, "I just got Hickcliffe locked up. That N-word put all my nudes on Instagram." Really, this whole case is a house of cards that's built on false allegations against appellant. The text messages show the complainant's motives for engineering his arrest.
And I imagine that was argued at trial, correct?
Well, what I think happened, and I'm asking this court to weigh the evidence. And what I'm saying is, I think that the jury did not properly weigh this evidence. I think it's highly significant, and I think it got lost.
So again, all of the text messages, the testimony, et cetera, again, was put before the jury, and the jury made a determination based upon the evidence that was presented to it.
Right.
Is that correct?
That's
You're
correct.
arguing that somehow they were confused by all of the events that were going on, and so therefore their confusion led them to a verdict that was not supported by the evidence.
No, I'm saying that this is a case where a different outcome would not have been unreasonable, and that is why I'm asking.
Based on what?
Based on the fact that these text messages, if you give them actual consideration.
But again,
the
jury considered the text messages.
Well, I'm asking
was made aware of the text messages.
They absolutely were. But you have weight of the evidence review. You're the 13th juror. You're the second jury. And that's what I'm here asking you to do.
Counsel,
and that's your role. When
should we look at the
excuse me?
Should we look at the text messages in a vacuum and not look at the other testimony that was elicited of the witnesses?
Absolutely. The text messages basically tell one story. The testimony tells another.
Totally
and that's what's interesting about this case. And that's why the text messages are important. And that's what I think probably, if I had to guess, if I was a juror, I would have been overwhelmed by hearing all.
Again, see, Counselor, that is you.
That's me.
You know, that is you. Was there anything in the record to suggest that the jurors felt overwhelmed or that the jurors felt any type of confusion? Any notes from the jury which would support your argument? Anything saying, you know, could we have readback of the mother's testimony, or, you know, could we have readback of the text messages, that portion of the testimony relating to the text messages? Anything in the record which would support your argument that there was any confusion or feelings of the jury being overwhelmed by this information?
I don't recall any notes to that effect, but I don't know if, I guess I'm not understanding. Is the court saying it will not consider the weight of the evidence, which we're asking the court to do?
What I'm saying is that you have to give us a basis as to why you believe that we should substitute or our ruling in place of the jury's determination.
That's what I'm trying to do.
So what would lead us to believe, again, that the jury's determination was against the weight of the evidence?
What would lead you to believe that is that I think if you give appropriate weight to these text messages, you will see.
If I hear text messages one more time, I'm going to scream.
Yes,
and I just got a text message. Again, let's go back to Justice Mendez's point. It's not in a vacuum, okay? I mean, there's other evidence that was submitted, is there not?
Yes, and you know, this is what I think happened. I think that the story that came out, just start with the first incident. They're having a big family feud. He goes over to a complainant's apartment to try to work it out. They've been having an affair. Her mom shows up.
But I'm sorry, and I got to stop you there. I know you have a red light. The jury heard that. The position of the defendant was that they were having an affair, and it was rejected.
I guess I just don't understand how I can get the court to consider my argument about the weight of review, and that's your view of the weight of the evidence.
Counsel,
I'm trying to present
your
a
time
view
is
to
up,
you.
but I just want to be clear. We understand your argument. We're certainly considering your argument. The questions are intended, or at least the questions by myself, are intended to flesh out exactly what you believe the issue to be, and whether, more importantly, there's anything in the record which would, or not in the record, which would substantiate your position. You'll have time on rebuttal. Thank you.
May it please the court, my name is Ellen Friedman, representing the people. Your Honors, The jury heard all of the evidence before it, and there's no reason to question its determination or its credibility determinations. One thing that I wanted to point out is that the victim was asked to explain those text messages and what she meant by them at trial, and she did. She explained that when she said, once I heard mommy, I made my exit, it didn't mean that it was a voluntary exit. It was just a phrase she used to mean that's when she got out of the room. As far as the other text message, she said, I got him locked up. That she explained that didn't mean that she was framing him, that she got him locked up for something he didn't do. She said she didn't go into the details, but the fact is she reported him for a crime that happened that day. And the text
Counsel,
message
can you
doesn't.
address ineffective assistance, please?
Sure. Well, the first thing I want to mention about ineffective assistance is that there was no 44010. And so that's what would have given defense counsel the opportunity to explain why he didn't cross-examine Yanisel to lay the foundation for the statement in question. So it's hard to say there was ineffective assistance without that explanation. But in any event, it is clear from the record that we have that there was no error, there was no error in failing to lay the foundation, that it was for some strategic reason, and in any event, it wouldn't have been prejudicial because it was largely cumulative, credibility, impeachment evidence. So, first of all, the defense counsel put on a strong defense case, also vigorously cross-examined the victim and the other witnesses, got a beneficial Sandoval ruling, and got the defendant acquitted of 2 of the 12 charges against him. And the fact is also that he did attack the victim's credibility regarding the November threat incident, argued that she got the defendant falsely arrested because she was upset about his posting the photos, elicited that she had sent the posts with the photos to a prosecutor who said he couldn't do anything at that point, crossed about that text message, and also made the argument that she said something to the neighbor that led the neighbor to believe that she was framing him for that incident. So he made the point he wanted to make without asking about the contents of the evidence. It wouldn't have added much value.
Well, but the jury was not, the jury would have been made aware that there was a prior inconsistent statement, right?
Well, it would have been additional evidence. He already made the point that there was some prior inconsistent statement. Said that Yanisel said something to the neighbor that made her think she was lying when she made the police report.
Would that not, your adversary argues that because of that, that would have affected the jury's verdict.
Right, I believe that it would not have. But in any event, beyond that, the record indicates that it wasn't an error, it wasn't erroneous at all, that it was a strategic decision. It doesn't show that he was ignorant of the law. He said he wasn't planning to ask Albania about the substance of the statement, and that's why he didn't ask Yanisel about it. He didn't seek to recall Yanisel after the court explained the rule. The court went over the same rule the day before with regard to another witness. So instead it indicates that he decided not to ask her because of a strategic reason. He thought it would do more harm than good. In order to know exactly why, what the strategy was, there has to have been a 440-10.
Counsel, the defendant got 14 years, is that correct?
Yeah, the aggregate.
Can you address the argument that the sentence should be reduced?
Sure. He got a 14-year term, 2 years below what the people were seeking. The crimes were especially egregious, 3 separate incidents that occurred over the course of a year. He terrorized the victim and her children. He got himself into her home by threatening to ruin her life if she didn't let him in. He threatened to kill her and her 5-year-old, sexually abused her, threatened her, ordered his family members to attack her. Her children, and she described the situation as living in hell. The children were depressed and anxious. They were terrified to be in their neighborhood, to walk to school, to go to school, to be without their mother. And beyond that, he had an extensive criminal history. He showed no remorse. He continued to smear the victim at sentencing. And the sentence was richly deserved. If there are no further questions, Your Honors, I'd like to rest on my briefs.
Thank you.
Thanks.
Well, I guess I'm going to move on from the text messages. It's in the briefs, and I hope you'll consider it seriously. The appellant received consecutive prison terms that the court could have sentenced him to less than half of what he actually received. I think that this case is about a fight that's been going on between these two families for a long time. I think that we would not expect to see this kind of behavior. I don't think it's one-sided behavior as it was presented. I think the text messages show a completely different side of the complainant and her family. And they're not just complainant's text messages. There are her sister's text messages, and there's a text message from appellant to complainant. And I think that there's a subtext going on here that was lost in the emotion and the upset, that drama that came to the courtroom with children crying and the woman crying all the time. But when she was asked to explain why she said, "Once I heard Mommy, I made my exit," she said, "I don't know, that's what I wrote." Is that a good explanation? How many rape victims get to decide when they're going to end the attack? That's basically what she said she did.
Did the defendant ever accept responsibility for the crimes?
He denies that they happened at all. He said
has
we
no
were having an affair.
Zero remorse, zero acceptability of the jury's verdict.
Yeah, and I don't blame him. I mean, if you didn't do it, you didn't do it.
You're asking us to reduce his sentence. So that's certainly one thing that we're going to take into account.
Well, I'm asking you to consider it in light of his record and
what is his record? Is this his first conviction?
He was a drug dealer. He wasn't a prior sex offender. He had a unlicensed automotive thing. He had a couple of felonies related to selling drugs and things like that. That's how he made his living. He wasn't a sex offender.
Thank you so much, Counsel Lee. People versus Michael Rosario.
Yes. May it please the court, Whitney Elliott of the Legal Aid Society for the appellant Michael Rosario. What's at stake in this appeal is whether Mr. Rosario should remain on parole supervision for 1 year and 8 months or for 2 years and 8 months. Mr. Rosario's remaining on parole supervision for 2 years and 8 months would be unduly harsh for two main reasons. First,
Has he been on parole before?
he had been on parole before, yes, Your Honor.
And actually, he was on parole when he committed this crime?
That is correct, Your Honor, yes.
And so now you're saying that, well, actually, your argument makes sense. Parole obviously does not work because he was on parole when he committed another crime. So we should reduce the parole time because it's not going to do any good, right?
That is our bottom line. I think our main points for why are, number one, before sentencing in this case, he had shown a maturity that he hadn't shown before. He had reconnected with 2 of his adult sons, one of whom spoke with the defense social worker in this case. Second, he was brought to tears when thinking about the harms he had caused to the victims, to himself, and to his own family members in such a genuine way that I think it shows him genuinely wanting to change and be there for his family in the future. He has also recently been granted parole.
But how does that affect him not being there for his family in the future? He's on parole. He just has to act a certain way, right?
Well, he'll be if the court reduces he'd be on parole for 1 year and 8 months. But the extended term, which would be between May 2023 and May 2024, puts him at risk of incarceration for missing an appointment.
Or for committing another crime.
Well, he would face that regardless of whether he's on parole or not, Your Honor. But, and so I would just say, a second main reason it would be unduly harsh is the views of experts in the area of community supervision that we think this court should agree with, that community supervision should focus on, be forward-looking and focus on individual growth and success, not backward-looking, trying to punish for past conduct and past criminal history. And they agree that community supervision generally should not exceed 18 months. Even if this court reduces his term as we've requested, he'd still face a year and 8 months of supervision. So I think for those main reasons, we'd ask the court to reduce his.
Was this an agreed to disposition by the defendant, by your client?
The defendant took the plea, was an agreement he reached directly with the court, not with the prosecution's consent, but what the court thought in its view was an appropriate sentence.
And at the time, he was facing a 33-count indictment?
33.
33 counts.
There were a total of 33 counts resulting from 6 separate incidents, Your Honor, yes.
6 separate incidents for which he could have been convicted if he went to trial and been sentenced to maybe consecutive sentences?
At least for 6 incidents, but I think there would have been a cap.
So the court, in essence, said, I'll offer you to plead guilty to 2 of these counts in exchange for this sentence, and he accepted.
Correct, Your Honor, but I think because the court, just looking at him in all the circumstances, didn't even, those maximum consecutive sentences weren't even, they existed in theory, but no one thought that those were appropriate. Even the probation department thought that 2 to 4 was appropriate. And
he was on parole. When he committed these offenses, he was on parole, correct?
Yes, he was, Your Honor, yes. Thank you.
Good morning, and may it please the court. Molly Morgan on behalf of respondent. Defendant's bargain for sentence is entirely fair and appropriate. As Your Honor pointed out, defendant was charged with 33 felonies following a string of highly orchestrated thefts, many of which were documented on surveillance footage. Moreover, defendant committed the instant crimes while on parole for another theft offense. The people submit that an additional year of supervision is entirely necessary in light of the fact that defendant committed this orchestrated string of crimes while he was already on parole and had his parole revoked in the past as well. Unless the panel has any questions, the people were...
Counsel, yeah, I do. Can you address the appeals waiver, please? The appeals waiver. Can you address the appeals waiver?
I'm sorry, Your Honor, I couldn't hear that.
Can you address the appeal waiver?
The appeal waiver? To my knowledge, there was no appeal waiver in this case.
There was no appeal waiver in this case? Okay.
Yeah, that's correct, Your Honor. And again, this was a sentence that the defendant bargained for directly with the court and the people. Before defendant pled guilty in light of that agreement, the people noted defendant's criminal history and that he was a predicate felon. Unless there are further questions, we request that you affirm. Thank you.
Thank you.
I guess two quick points in rebuttal. Yes, in response, just saying that there was no appeal waiver in this case, and I guess I would just emphasize that given the maturity that Mr. Mersario showed, reconnecting with his sons, being brought to tears and showing genuine remorse for the harms he had caused to the victims, to himself, and to his family, requiring him to serve that extra year of parole supervision between 2023 and 2024. About 6 years after these nonviolent offenses happened, would be unduly harsh and excessive. Thank you, Your Honor.
Thank you so much. Thanks, V. Chan.
Good morning, Your Honors.
Good morning.
Margot Flug for the Mental Hygiene Legal Service, representing appellant Wilson C. May it please the court. In this proceeding to terminate the guardianship, the burden was on the guardian to prove by clear and convincing evidence that Mr. C was incapacitated and in need of a guardian. The guardian failed to meet that burden. The record shows instead that the guardian's own caseworker conceded that Mr. C managed all of his activities of daily living. They could not identify any areas in which he's unable to care for his personal needs. The record also shows that Mr. C is highly aware of the gravity of the landlord-tenant case that he is facing, and he's seeking counsel of his own to go forward with that case as quickly as possible.
Was proof of mental illness shown here based on sort of the unusual behavior that your client displayed in his apartment, sealing parts of it because he was concerned about noxious substances, et cetera?
Well, Your Honor, there's two parts that I would answer to that question. The first thing is that the unusual behavior itself was speculative and actually resulting from a bias and potentially prejudice trying to build an idea or a speculation of what Mr. C's state of mind was when he did those alterations, possibly stemming from my second point, an uncertain diagnosis that was glancingly brought up by the caseworker for the guardian. There was no medical testimony. There was only one reference to the fact that there had been what was considered preliminary assessment by some sort of psychologist or psychiatrist, and that psychiatrist or psychologist themselves said that they thought that a real, quote, real actual psychiatric assessment would be needed. But the main point is that Article 81 is very clear that guardianship should not be based on the existence of a diagnosis. The purpose of moving to the Article 81 framework of functional approach was to make sure that a court cannot, or that these guardians cannot derive from the mere existence, or in this case, speculation of a psychiatric diagnosis, any other sense of what this person's limitations or abilities are. In fact, the court was supposed to be scrutinizing carefully the evidence to find out what Mr. C was capable of. And in fact, the guardian's witness themselves was saying this person is capable of taking care of all of his personal needs, and then speculating with very little evidence about what his state of mind might have been when he was doing these alterations on his apartment. It's also notable that there's no nuisance case, that there's a landlord-tenant case that is separate and that the court recognized to be separate, that the merits of that case would be dealt with separately, and that Mr. C understood the gravity of it, was looking for counsel in that case. And with such scant evidence, such weak evidence brought to the court, not meeting the burden that the guardian was supposed to meet.
But counsel, I want to get back to the point in terms of mental illness. Had there not been a diagnosis of Mr. C as that he was, I think, schizophrenic?
The record only talks about one interaction, one assessment in what they thought was April 2018.
Right, but also there was something in the record, I think, that one of the reasons why there had not been any follow-up or any subsequent diagnosis is because he would not submit to the same. Is that correct?
Well, it was mentioned that Mr. C was not interested in having the treatment that this caseworker said, or I'm sorry, having another assessment. But the point is that there was no assessment done, and that they're resting on, and that, by the way, no assessment is needed. The whole point of Article 81 is to look at his functional abilities, not to take one suggestion about a diagnosis. Even if there were an ironclad diagnosis, that in of itself would not be a reason to have a full guardianship.
He may have a mental illness, but he can still take care of his personal needs, and therefore they haven't established that the guardianship should continue. Is that your argument?
Thank you, Your Honor. Exactly. This is a person that the caseworker themselves said was taking care of all of his personal needs. Not only was it speculative and incomplete to mention that diagnosis, but a diagnosis in and of itself would not be enough. And the court would have to have specific findings explaining in a current sense, what his situation was now. The whole purpose of this type of motion under MHL 8136 is to, and this was stated in Rebecca P., is to, the salutary purpose is to lessen the difficulty of a person seeking to gain more control over their life. So this court needed, with very little evidence on the record, to look back to 2016 when it was instituted, and there's really nothing here in the current time when Mr. C is saying, look at me now, look at all the things I can do. Instead, the caseworker is saying, yes, he can do all these things, but let's speculate about a landlord-tenant case and about a possible diagnosis. Thank you very much. I'll reserve the rest of my time, please.
Thank you.
Good morning, Your Honors. May it please the court, the law offices of Jordy Fernandez by Jordy Fernandez for the respondent Self-Help Community Services. In this court, as you're aware, the lower court denied the appellate's motion to terminate the guardianship over his person.
Who has the burden?
The burden is pretty clearly clear and convincing
So you have
evidence.
the burden, and how, and it's clear and convincing evidence, you agree?
Um,
It's clear and convincing evidence?
That's correct, and it's self-help's burden, the guardian's burden.
Okay, so
that-
by clear and, how have you shown by clear and convincing evidence that the guardianship should continue? Was there medical testimony elicited with respect to the appellant's current condition, for example?
No, there were several events that demonstrated that the appellate needed a person to manage his property management, which was the nature of the cross motion. Number one, in 2016, Self-Help was originally appointed as the guardianship over his property. That was removed in 2018 by a subsequent order of the court. He immediately began to withhold his rent afterwards. He testified.
Okay, so he's making, he may have poor judgment, granted. But is that and he may get evicted, but is that a basis to essentially take his civil liberties away?
No, his inability to manage his own property for his own property management, and his inability to understand the consequences and the nature and consequences of action as well as a basis. And what he did, in addition to just withholding his rent, is he also obstructed the application for a subsidy. There's testimony that occurred in 2019 from Kingo, the caseworker, that he wasn't provided a subsidy. Should understand that that subsidy would have been about almost half of his rent. He wasn't just withholding his rent, he was stopping the ability to ever pay his rent by obstructing it. He did not.
And that shows that he's incapacitated?
That by itself does not show that he's incapacitated, but as
Because
you noted,
otherwise, I could take you down to housing court, and there are probably, more than a dozen people under the same circumstance.
I don't think for a claim for $2 million as a counterclaim to offset rent that's $800 a month, it is that. But in addition to that, he was diagnosed with schizophrenia. He was acting out in schizophrenia, and the record.
Wait a second, you say that he was diagnosed. Is there a medical record? There's no medical records in our record, correct?
That's correct, and not from.
No psychiatrist testified that he was diagnosed, and no assessment. It's just a social worker testimony, correct?
That's correct, from 2019.
So let's not say he was diagnosed as a schizophrenic.
Well,
let's say what the record says, which is a social worker says that he has psychiatric illness.
Okay, well, Judge Maisley found in 2016 in the original order that he was diagnosed with, and in 2019, Judge Wan's order noted that none of the conditions had changed from 2016 to 2019, and our clinician, Marsha Friedman, who's in the record, said that he was diagnosed with unspecified schizophrenia.
Was he able to feed himself?
Yeah, he was able.
Was he able to go grocery shopping?
He was able to go do the day-to-day.
Did he clean himself, take a shower every day? No issue with that.
That's correct. The record indicates that.
The main basis is that he's probably going to be homeless because he's messing up his housing situation.
That's correct. If he was left to his own devices in his property management, he would probably not be paying his rent and be left homelessness. And he didn't understand the gravity of it.
And that's it. That's it, right? That he would probably be left homeless. There's nothing else in the record to support a determination that he's incapacitated.
No, well, that is within that's it, that's correct. It's basically left with homelessness and you'd be left without a home, but that's,
So are there any cases that say that that alone is sufficient to continue a guardianship? That the individual would be left homeless? Or potentially homeless?
well, it fits within the Court of Appeals cases that are cited in a record of a functional limitation. He does not have he did not demonstrate the ability to show that he could maintain the rent and pay the rent. And not just pay the rent. It wasn't just he didn't have the means to pay the rent.
But he refused the subsidy.
He refused the subsidy. He refused to cooperate with the subsidy. When he had the ability to manage his own property management in 2018 following Judge Kelly's, he immediately began to withhold the rent and pursue this abatement claim for a breach of warranty of habitability worth $2 million. The rent is $800 a month. And to understand how far removed that is from reality, you should understand that that's 200 years.
But counsel, I mean, you're talking to several judges who've sat in housing court. That's not even like, that's like an everyday affair there. You're not giving us anything shocking, like someone saying, I've been injured because of what you've done to my apartment and I have big damages. That's not, we've all seen that many times. That doesn't stand out with this person. So other than that, the homelessness issue, there's really not diagnostic information in the record, and he is able to feed himself, clothe himself, take a bath, do all the stuff every day, correct?
That's correct.
Okay, thanks.
Your question?
Thank you, Your Honors. I would just point out that an important point is that in 2018, Mr. C still could not get his own counsel. So
yeah, why is that? Oh, because of the guardianship?
correct. In the record, it states that that legal aid, when he went there, said you have this nonprofit working on your behalf as a guardian. So as this caseworker who's been on his case for several years is still speculating what is his reasoning, we came in and settled. Mr. C is saying on the record, and it's uncontroverted, he's not getting his own invoices. He doesn't know what the settlement was about. He can't sit down with a lawyer and talk about his case. So when Guardian says, well, talks about the merits of the case, this is not something he's been able to consult with a lawyer about exactly because the guardianship is getting in the way, and that was his reasoning for bringing this case, and for whatever reason, without adequate evidence, the court expanded the guardianship rather than terminating it and allowing him to have his own independence and self-determination.
I have a question. Is it a rent control department he has, or rent stabilized?
It is rent stabilized, I believe.
Okay. So, but it's still a valuable property right, correct? And that's something that shouldn't be lost?
We don't have any information as to exactly what the merits of the case would be. Obviously, there was information that at one point the landlord was saying that he didn't have a right to the apartment, and that took a while to resolve. But again, I would say, Your Honor, that these would need to be addressed, the merits of the case in the separate housing case. And now, with the change in the law especially in 2020, he would have expanded rights to counsel in that housing court hearing no matter what, and finally be able to be counseled directly on his rights to that very valuable property. So we respectfully ask this court to reverse the whole lower court's decision and terminate both guardianships. Thank you.
Thank you. Taglioni versus Garcia.
Good morning, Your Honors.
Morning.
May it please the court, my name is Kevin McDonough. I represent the defendant appellant wife, Victoria Garcia. The parties have been married for 25 years. They were married in California in 1996. The parties' marital residence is a townhouse located on 18th Street in Manhattan. Pursuant to court order, the wife has exclusive occupancy of that home, where she lives with one of the party's 2 daughters when she is not away at college. The wife has been a stay-at-home mother and homemaker for many years.
So, counsel, we're concerned with the sale of that townhouse. So
Correct.
how did the court, or did the court properly direct the sale of that?
Correct. So one of the critical issues, Your Honor, is that the townhouse, according to the husband, because he's taken the position that everything else is his separate property, is the single most valuable asset in the marital estate. There was multiple conferences concerning the townhouse, concerning the East Hampton house, concerning there's the extensive repairs that are needed for the townhouse to be done. Nowhere in any of those conferences, there was obviously no motion ever made on any of these issues. Nowhere in any of those conferences was there ever an agreement on the record that the townhouse would be sold.
What about, I mean, at least according to my notes, there was a conference January 28th, 21, and at that conference, did the wife's attorney consent to the sale of the townhouse?
Absolutely not, Your Honor. So you're correct, there was a conference on January 21st of 2021. If the court, if I could point the court's attention to the record at page 17, which is part of the transcript of that proceeding, the wife's then lawyer says, "I will speak with my client," quote unquote, about the concept of potentially selling the townhouse. The court will recall that as part of the discussions and amongst the lawyers before that, the husband had agreed to transfer the East Hampton house to her. His lawyer on the record on the January 21st conference says, no, he won't do that unless she agrees to sell the townhouse. She had not agreed prior to that time to sell the townhouse. Her lawyer specifically says on the record at page 17 of that of the record, "I will speak with my client." The court.
So, counsel, you're saying to us that there's no agreement, yet you submit an order to the court for the sale of the. How could that possibly be? There's no agreement. You say, not only am I not signing your order, not only is this order, you submitted your own order. It's not like anything you did at that time. If you don't think there's a deal, you don't submit an order, but you did.
No, I'm sorry, Your Honor, but that's not accurate.
There are 2 orders, correct?
Correct.
What does your order say?
Says there will be no sale of the townhouse unless there is a further stipulation. I can quote the exact language for Your Honor. That is clearly, there was never an agreement, and the order that the wife's then counsel submitted specifically said that it was subject to a further stipulation between the parties. The exact language is, the townhouse will only be sold under the terms of an agreed stipulation between the parties. That's in the order. The husband's counsel took it upon themselves, despite there being no agreement, and to Your Honor's question with respect to whether there was an agreement at the January date, there was not, and in fact, the court says in that conference date that there was an agreement on doing the repairs to the townhouse. There was an agreement on transferring East Hampton to her. There was no agreement with respect to the townhouse. That's at the record at 22.
What about the January 28 conference? The attorney says, the wife's attorney says, to be clear, our client at the end of this case, she is agreeing. She's not planning on keeping the family townhouse. She has no intention of keeping it.
That's at the end of the case, and that's just consistent with what the law is. The court does not have the authority to order the sale of a marital home, jointly owned home, until there's a judgment of divorce, absent some extraordinary circumstance, like it's in foreclosure or there's financial extremis. The lawyer at the January 21 conference specifically said the court is absolutely correct. At the end of the case, we're probably going to agree to sell the townhouse.
So what we're proposing is that if this townhouse is sold on a pende lite basis, that plaintiff as the moneyed spouse shall pay for a reasonable rental for our client in Manhattan.
Which he
goes on to say the mortgage is approximately $1 million. That's the outstanding mortgage. The broker stated they believe it will sell for approximately $6 million. That should be the asking price.
That's all correct, but there's no agreement. And again, Judge, that's at the end of the case, when all of the other assets are divided. It's a typical circumstance to say, when I get my support and I get my equitable distribution at the end of the case, I'm happy to sell the townhouse. I'm not selling it in the middle of the case. And again, to the court's specific question, was there an agreement? Judge Katz says on the record at the January 21st conference, I'll quote, Judge Katz says, I think your client should consider that. It's the record, page 27. Judge Katz goes on to say, I heard Ms. Shanfield say she's going to discuss the issue with your client. The record at page 36. There was no agreement. At the March conference, the husband's own attorney says on the record that she has not agreed to sell the townhouse, and they complain about that fact. The judge says, submit an order about the repair issue only. They take it upon themselves to submit an order which goes well beyond that and orders the sale of the townhouse where there was no agreement. There was
So why would there be a request to submit an order as to the repairs if, I mean, we have not gotten to the end of the case, so if we're not going to sell the townhouse now, and we're not selling the townhouse until after the case is over, why are we dealing with issues as to repairs now?
Because the repairs have to be done anyways. The repairs have to be done before the house could ever be sold in the future, and it also goes to the habitability and the maintenance of the value of the house. These are fireplaces and roofing issues in terms of the preservation of the value of the house going forward. But one has nothing to do with the other. And just, I see the rights on, but the law to me is clear. The court cannot order the sale absent a clear agreement and a meeting of the minds, which there was not in this case. Thank you.
Good afternoon, Your Honors. Gretchen Schumann, Rabin Schumann and Partners for
But
respondent.
there was no agreement. There was never an agreement to sell the townhouse.
No, Your Honor, there absolutely was an agreement, and I would like to point out in the January 28th transcript, Judge Katz has been with these parties since 2017. This is a 2017 action. There have been 17, now 18 motions filed in this case. He is very familiar with this matter. This did not come out of a vacuum. The first thing he says is, we've been talking about the sale of the townhouse for 2 years. 2 years, get it done. There is extensive discussion on the record,
could you focus me on specifically in the record where the wife's attorney agrees on behalf of the wife to sell the townhouse?
Most certainly, Your Honor. In fact, to put this in context for Your Honor, the parties had also engaged co-brokers at this period of time to prepare the house for sale, to get the recommendations to prepare for sale. And in fact, the wife's attorney...
But counsel said, you know, this is going to have to happen anyhow in terms of the repairs. So again, this is going to have to happen anyhow in terms of the co-brokers. So again, where in the record is it stated that she agreed to sell the townhouse?
Well, first of all, the wife's attorney, Your Honor, on January 28th, says to the judge, the listing price should be $6 million. Okay, this is post-appraisal. She says it should be $6 million.
It implies an agreement. The question is there an affirmative statement by the wife's attorney that, yes, my client has agreed to sell the townhouse?
I believe there is, both in the transcript, Your Honor, and I will get there, then again on March 30th, and then with respect to, and I'll talk about March 30th
January
in a moment.
20th and March 30th?
January 28th, yes. And what the wife's attorney actually said to the judge was, I will discuss with my client what Your Honor has said about the proceeds. The proceeds. There are no proceeds if there is no sale. We were absolutely talking about a sale.
When is the sale going to take place?
The sale was to take place pendente lite. And the reason we know that, Your Honor, is because subsequent to the March 30th appearance, which I will go back to, in April, the judge had said, submit orders on notice. Everyone had an opportunity to be heard. Respondent submitted his order on notice.
Is counsel right that there was also language saying at the end of the case?
No, Your Honor. In the proposed counter order that was submitted by the appellant did not say sale at the end of the case. The appellant said within 30 days of completing...
I understand the order doesn't say it, but on the January 28th, was there a reference to at the end of the case?
The reference to the end of the case is actually being taken out of context by appellant. The reference was, my client has basically no intention of holding on to this house. That was what the reference was into. And then appellant's counsel said, well, if Mr. Taglioni pays for alternate housing, she'll agree to sell the house now. But subsequently, Your Honor, quite frankly, appellant submitted a counter order which says within 30 days of the broker-recommended repairs being completed, the house would go on the market. The only thing that she didn't substantively respond to was respondent's protocol for the sale of the house. That's different than consent. The matrimonial court has every power and every ability to set a proper protocol. In a case where there are 17 or 18 motions stating, well, the parties will figure out the protocol pursuant to stipulation.
So in other words, what you're saying is that the matrimonial judge could impose conditions that the parties don't agree to?
I believe the matrimonial judge could impose conditions with regard to the sale once there's consent to the sale.
Now,
And that's the
counsel,
case.
let me ask you, how is reducing the sales price by 5% a protocol? That's clearly not a protocol. That's a substantive valuation decision that the parties should have made together. And there's nothing in the record of the wife saying, yes, I agree, if we don't sell the property, I'm going to keep reducing it and reducing it and reducing it. Wouldn't you have to have a specific agreement to that?
Well, Your Honor, in this respect, I would posit that Judge Katz was looking at the 5% piece as a dispute resolution mechanism. Actually, the order provided.
It's not a mediation, it's in an order. That's what we're dealing with right now. The judge said, plus I'm going to impose this reduction in price on you. Aside from whether or not the parties agreed to sell, that piece of it, was there ever an agreement on that 5%?
Your Honor, not on the 5%, but it was if the parties and the brokers do not agree. That was the tiebreaker, if the parties and the brokers do not agree. Almost every matrimonial decision where there's a sale of a property, the court sets a protocol for the sale. Otherwise, you're back in court. I see my time is up.
Thank you.
Thank you.
Thank you, Your Honors. I believe the court asked counsel 2 or 3 times, where in the record did the wife's attorneys agree to the sale? The court didn't get an answer because it's not in the record anywhere.
And that may be, but isn't there a strong argument to be made by submitting the order on behalf of the wife that there was a meeting of the minds with respect to sale of the townhouse while the matrimonial action was still pending?
Again, Judge, the husband submitted an order which had all these provisions about the sale and the 5% and the $6 million. And the $6 million was a number that was discussed in December of 2020 in the middle of COVID, and it was a sale price, not a listing price. But putting that aside for the moment, they submitted an order with all these provisions about the 5%, et cetera. The wife submitted a counter order. The wife's counter order said it dealt with the repairs and payment from the escrow to do it with the fireplaces and the roof, et cetera. And it said the townhouse will only be sold under the terms of an agreed upon stipulation between the parties. There was no agreement to sell the townhouse under that. The counter order they submitted demonstrates that. There was no meeting of the minds, there was no discussion of terms to the court's questions, et cetera. And to go back in terms of the timing and when it was,
why submit a counter order? Why not state, or if you're going to submit a counter order, why not say, but none of this is going to take place until the end of the case?
I wasn't the lawyer then, so I can't answer why they did what they did, but they did not consent.
But do you see how perhaps not doing that could lead to some confusion and some thought on the part of the husband and the court that this was agreed upon, that the sale was agreed upon?
I honestly don't, Your Honor, because the order that they submitted, the counter order, did not deal with the sale whatsoever. So I'm not sure how anybody could perceive that as any kind of agreement. Thank you, Your Honor. It's nice to be back in person.
You are? You're crazy. Thank you. Glencore versus Freepoint. Why? Oh, yeah.
Good afternoon, Your Honors, and may it please the Court. My name is Francis Healy with Strzok & Levan on behalf of Defendant Appellant Freepoint Commodities, LLC. In its decision below, the motion court denied Freepoint's motion to dismiss, which was based on a binding certificate of analysis demonstrating that the fuel oil Freepoint delivered...
Hold on a second, hold on a second. Does the certificate say that it's final and binding?
The contract agreed to by the parties said the quality of the fuel oil to be delivered was to be based on the analysis by the independent inspector mutually agreed by the parties.
And does it go on to say that it'll be that determination will be final and binding?
The contract does not include the words final and binding, but we think that's irrelevant. The contract
Irrelevant? It's not, you're saying that's not relevant?
I don't think it changes the analysis, Your Honor. I think the contract language is clear that the analysis, the quality of the fuel oil as defined in the contract, and it lists the required quality specifications and the testing methodologies, that quality is to be based on the independent inspector's analysis as mutually agreed by the parties after loading.
So counsel, don't you have two? Don't you have two analyses of the fuel oil which contradict each other?
Well, there are several analyses, but the analysis that
Well, let's start with, at the beginning, you admit it's not going to pass. The stuff that you send the first time isn't going to pass, right? So
Well,
that one, you can't, that analysis is definitely not going to support your view. Then you say, let's blend it. So you send it somewhere else, you blend it, then there's one test that says good, and then a next test says not good. So how is it that you have proved as a matter of law that you've complied with the contract?
Sure. So after what happened at Houston, and it's a Freepoint we dispute the fact that whether we delivered initially at Houston was off spec or not, but for purposes of this motion, Houston we think doesn't matter. The parties mutually agreed to divert the vessel to Glencore to reblend the fuel oil. After that reblending operation, the full cargo of on board the vessel was tested by the mutually agreed independent inspector, and that was a test performed under the original contract.
Wait. How do we know that? Why not under the mitigation contract? How can we determine as a matter of law, or put another way, how does it utterly refute the plaintiff's claims?
I missed the second part of your question, Your Honor.
How does it utterly refute the plaintiff's claims? Because we can't really determine. Can we determine at this point as a matter of law which contract the test was performed for?
Absolutely, Your Honor, and it's clear on the record, and it's admitted by respondent in the affidavit that was submitted. First of all, the certificate of analysis that Freepoint relies upon and submitted expressly references the contract number of the original contract between the parties, and that's number 518-0529.
But it occurred, it occurred after the fuel is sent to St. Croix to be reblended, so couldn't it arguably be applied to the mitigation contract?
I disagree, Your Honor, because the parties mutually agreed to divert, right? So through their actions and their course of conduct, they amended the terms of the agreement. Delivery is now in Lime Tree Bay, and the quality is to be determined by the newly appointed independent inspector. After the reloading operation in Lime Tree Bay and St. Croix, the mutually agreed independent inspector performed an analysis of the entire cargo of fuel oil after that blending. That certificate, which showed undisputedly that every quality specification came back within the requirements under the contract.
And then approximately 3-4 weeks later, in August, as my colleague points out, there was a contrary test. So what's the effect of that?
Correct. So let me address the first point. So the one issued in July 11th, right after the reblending operation, again, Glencore's head of operations admits in his affidavit in paragraph 10, on page 140 of the record, he admits that inspectorate and the certificate that it issued certified whether the low sulfur fuel oil met the minimum and maximum quality specifications, quote, set forth in paragraph 7 of the contract, capital C, using the testing methodology set forth therein. The only contract that has any minimum or maximum quality specifications is the original contract, not the mitigation or lime tree contract as you referred to. That contract is silent as to any parameters on quality or any testing methodology. So it's undisputed on the record that the only contract under which the inspector issued the certificate of analysis in July 11th was under the original contract.
Well, that sounds like a summary judgment motion, that's what it sounds like to me.
I think under the CPR 3211, we think this evidence is submitted as dispositive, and that's why we made the motion. And to address the later issued certificate of analysis, that occurred after Glencore or respondent's purchaser, Glencore accepted the cargo, paid for it in full, directed the vessel to sail to Argentina. It was only months later, weeks later, after its purchaser rejected the cargo based on a completely different analysis. Then it goes back unilaterally to the inspector and unilaterally requests a new certificate in order to try and match.
But again, but would that violate the contract term? Had the contract contained language that is final and binding, I think you'd have a strong argument. But under these circumstances, is it?
Again, I disagree. I think the contract language is clear. It's to be based on the inspection after loading at that time.
So, counsel,
give credence to
let me just ask you about going back to which contract applies. The plaintiff alleges that a different contract applies to those July 18 certificates than you, correct?
They allege that, but that's...
So that, and on a pre-answer motion to dismiss, right, we accept that allegation as true. And what are you saying to us irrefutably disputes that allegation?
Well, that allegation was not made in their complaint, in their initial pleading.
You're just saying that there's a number on the contract,
right,
or the number on the certificate, which is by a third party, not the plaintiff, right?
Correct.
So the plaintiff has no control over that. And the plaintiff is alleging that it's a different contract. So why are we dismissing this now? As Justice Singh says, do your discovery, and then we'll decide.
Well, plaintiff's response did not make that allegation in its pleading. It only made that allegation in response to our motion to dismiss. Also in response to that motion to dismiss, respondent's head of operations globally admitted, and I quoted, it's on page 140 of the record, paragraph 10 of his affidavit, and he admits that the inspectorate, the independent inspector who issued the certificate of analysis on July 11th and 17th that Freepoint relies on, it analyzed whether the low sulfur fuel oil met the minimum and maximum quality specifications set forth in paragraph 7 of the contract. That's an express admission that that certificate of analysis was issued pursuant to the original contract, not the second, Lime Tree Bay contract, which served one purpose only. That was only the reloading and loading of the 25,000 replacement barrels. That had nothing to do with the testing of the full load that was delivered by Freepoint.
Thank you, counsel. Your time on rebuttal.
Thank you.
Your Honors, good morning.
Counsel, is the delivery of the fuel oil in Houston relevant to this appeal?
Yes, Your Honor. In fact, I would contend that it is the only thing that is relevant on this appeal. This claim is for breach of the contract in Houston based on the delivery of all specification product that took place in Houston. And I think there's been some fuzziness in the description of the testing provision of that contract. What that contract requires is that quality is to be based on the test of a mutually appointed inspector, either from Freepoint's short tank in Houston or from Glencore's vessel after load. And the parties did appoint an independent inspector under the Houston contract. It's a company named Cayman Cargo, C-A-M-I-N, who took tests, took samples in accordance with the contract. Those certificates showed that the fuel did not meet specifications. We had the admission for purposes of the motion that the fuel did not meet specifications in Houston. And under SEMPRA is about contract interpretation. What do the parties agree to? That is the certificate that counts under the Houston contract. Everything that happens after that, the attempts at mitigation, the various samples, the tests. There are multiple lab reports in this case concerning this cargo. Everything that happens after that, there is no agreement that it would have any impact on the rights and obligations of the parties under the Houston contract. That's the point.
But can we, so it's your position, how does the July testing, what position, is that under the mitigation contract? Is that your position?
So, Your Honor.
Something else?
Yeah, Your Honor, I think there's been kind of a false choice presented here, which is that either the lab report is the official report under the mitigation contract, what we call the Lime Tree Bay contract, or it's the official report under the Houston contract. But there's a third possibility, which is the reality, which is it's not an official report under either of the contracts. The point of that test, and this is explained in the McNamara affidavit that was selectively quoted from by counsel, the point of that test is Glencore has now purchased the 25,000 barrels in Lime Tree Bay and blended that with the cargo on the ship. It needs to know what's on the vessel because it has an on-sale obligation to its customer in Argentina, and they're in the middle of negotiations with that customer and trying to figure out if we have an off-spec cargo, do we offer discounts, how do we deal with this? It was a commercial purpose. That's the point, or that was the purpose behind the test. And there's a little bit of confusion again in the affidavit because the specifications for the contract for sale to the customer in Argentina are the same specifications as the specifications under the Houston contract. So when you see reference to testing for those specifications, it's the same thing. It's the same thing. The commercial purpose was for, as I said, for Glencore to figure out what's on the boat.
So, counsel, how do you explain the council's reference to the contract one on the second, on the testing after the blending? Why would you have that contract on there if that wasn't, if that didn't apply?
Your Honor, first of all, I mean, a number in and of itself is not an agreement.
I'm not just, but I mean, it does indicate something. I'm testing under this contract. I mean, that's what you generally do. You don't test under some other contract.
Your Honor, it could very well be that the slate from the Houston contract was provided to the inspector. That's one possible explanation. Another possible explanation is that that inspector, which is a different inspection company, by the way, than the one appointed in Houston under the Houston contract, but that inspector also played a role in Houston. They were appointed, it's a little confusing, they were appointed by the customer in Argentina to observe and participate in the Houston load. It could very well be that they just used the same client reference number in St. Croix because it's the same parties, it's the same vessel, it's a similar cargo, it's not the same cargo. But there's no explanation for it in the record, and there's certainly nothing that establishes as a matter of law on the face of the document that that's an agreement to be bound or to waive claims under the Houston contract. And that's what's required on a motion based on documentary evidence. Everything has to be unambiguous and clear and leave no doubt, no room for factual dispute. And I think that at best, the insertion of that number raises a factual dispute. Your Honor, just, I guess, two more brief points has been raised by, was not raised by counsel, but there are two other arguments that were raised in the briefs. I don't think they're properly before the court. There's this right to reject notion. That was something that was raised for the first time on reply at the motion court. And there was an argument based on an event of default provision raised for the first time on reply on appeal. I don't think the court needs to address those, but if the court would like to hear my thoughts. Yeah, okay. Then with that, Your Honors, I'll rest unless there are any further questions.
Thank you.
Okay, thank you, Your Honors.
So just briefly, I want to return to what counsel just referred to and additional reasons why loading in Houston we think has no bearing on this motion. As referenced by counsel, Freepoint had even assuming that there was some nonconformity in the delivery at Houston.
Wait, is that undisputed? I mean, is there a dispute about that? Wasn't there a test done? And why would the oil be diverted to St. Croix if it met the contract specifications?
So, and I don't want to confuse the matter unnecessarily. So prior to even loading at Houston, there was a testing done of the hand blend.
And that's what counsel relies on. Counsel says that's the testing that counts.
I think it's a little confusing. So the original testing showed all the hand blend on specification. If it didn't show that it was on specification, the parties wouldn't have loaded the vessel in the first place. After it's loaded into vessel, while still in Houston, there were additional tests, non-contractual tests and analyses that were done by Glencore's purchaser. Those analyses showed some inconsistencies and some specifications came back off of specification. So despite the fact that the preload certificate showed the fuel oil on spec, the post-load shows some inconsistencies. The parties, as an accommodation and how it's common in the industry, mutually agreed to divert the vessel. And that's why everything shifts to St. Croix, because even if there was a nonconformity, which again, we dispute that it was off spec when delivered, we don't dispute that the parties agreed to divert to Lime Tree Bay. And even if there was a nonconformity in the fuel oil originally loaded, Freepoint had the right to cure or remedy that nonconformity either under the contract or under the UCC. And I know counsel referred to the fact that this was raised for the first time on reply. With regard to the UCC, that was raised directly in response to respondents' argument that the Lime Tree Bay loading was irrelevant and relied solely on Houston. Therefore, in response, Freepoint argued that even if there was a nonconformity, it had the right under the UCC, and there's sufficient evidence in the record that demonstrates why the elements under UCC 2-508 are applicable. And with regard to the contractual right, the contract is clear that an event of default or breach only occurs when the nonconformity is not remedied within 30 days. So, and while not raised initially on our papers, this court has the ability to consider that argument because it's clear on the face of the record. The contract was part of...
Is that a legal argument or is it more a fact-based argument? And if it's a fact-based argument, I would submit that we don't have the authority, but if it were a legal argument, we do.
Well, I think it's a legal argument based on facts that are part of the record. The contract provisions are part of the pleading, they're part of the record, they're on the face of the record, and therefore we contend that this court can consider that argument.
Thank you very much.
Thank you very much, Your Honors.